Good evening. This is a regular meeting of the Planning Board of Princeton. It's Thursday, February 6th, 2020, and the opening statement is as follows. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the 2020 agenda resolution of the regularly scheduled meetings of Princeton Planning Board. Such notice has been placed on the official bulletin board at the Princeton Municipal Complex and is to be maintained throughout the year by transmitting a copy of such schedule to the Princeton Packet, Town Topics, The Times, Trentonian, and Comcast Media. A copy has been filed with the Clerk of Princeton on the 8th day of December 2019. Legal notice on the adoption of said resolution appeared in the December 2019 edition of the Princeton Packet. Would you call the roll, please?
Ms. Capizzoli, Mr. Cohn,
Here.
Mr. Oakman,
Here.
Mr. McGowan,
Here.
Mr. Quinn,
Here.
Ms. Sachs,
Here.
Mr. Texarney,
Here.
Ms. Wilson,
Here.
Mrs. Gunning,
Here.
Ms. Spalla,
Here.
Mr. O'Donnell.
Here.
We have a quorum.
Thank you. Among the announcements, I need to point out to you that the February 20th Planning Board meeting, that's the one 2 weeks from today, has been canceled. So you can mark that on your calendars. And I believe Ms. Wilson wanted to make some announcements about master plan.
Thank you, Madam Chair. Just would like to give folks a bit of an update on the progress of the green building and sustainability element of the master plan, which the master plan committee has worked on for a couple of months following receipt of a draft from the Princeton Environmental Commission. The master plan committee will meet on Friday, February 21st at 9:30 in the morning at meeting room A, which is that away.
Next door.
Next door to this room here. And at that meeting, we will be discussing and hearing any input and feedback from the public on the draft plan. So I guess that, well, master plan committee members are submitting comments. We will generate a final or penultimate draft in time for Eileen to distribute it and make it available to the public. I think 10 days ahead, or at least a week ahead of the master plan committee meeting. And then if all goes well at that meeting, we will put it on the agenda to recommend to the full board in March. So that's the time frame that we're working on right now. That's not to say things couldn't change a little bit if there's feedback that we feel, you know, requires another draft, but that's where we are right now.
Okay, thank you.
Mm-hmm.
I should also mention that you should have received by email now the committee lists and so on, and if you've decided you want to change committees or discuss it with me or Eileen, please let us know, because we really need to move ahead on the committees. All right, so the next item on the agenda is the findings of fact for the Princeton Charter School, and I believe we have a communication on that. Do you have that, Jerry? Or I do.
Yes. There's been a change in the resolution that was circulated, and on page 5, paragraph 24B, second line where it says conditions D and H, the and H has been eliminated. And then moving on, actually it's on page 9, and is that a new section H?
No, that's the original condition that the attorney has requested to be removed from the, if you read the text in the email.
Oh, that's the condition that's being eliminated.
Right,
Yes.
okay, remember, it was the prior conditions that were included.
Right, so that highlighted H is the condition being removed.
Eileen, has the board seen these changes in conditions at all?
I just distributed tonight. It's in front of everybody tonight.
All of you should have a copy of this. I think, if I can remind you, the board had hoped that the change in plans would enable the applicant to save this tree, which had been marked for removal in the first set of plans, and the findings were written to indicate that the tree would be saved. I gather they no longer can save the tree, and so they've asked to return to the original findings, which said that the tree would be removed and it would be replaced by 2 trees. Any comments from board members on that, or anyone?
I find it disappointing because they so readily said, oh yes, that will enable us to keep that tree, and it's a great big tree. So, you know, I don't mean to, well, it's not making a mountain out of a molehill. If they have to remove it, they have to remove it, but it's frustrating to hear something at a meeting, put it in there, and then have them come back and say, oops. Because it's not just a little bitty thing. That's just my 2 cents.
Okay, anyone else? Other than that, would someone like to move approval for the findings of fact? Anybody? Go ahead. Right. Okay. Is anybody who's eligible to vote on this thinking of making a motion at this point?
I guess I'll move approval.
Okay, thank you very much. Anyone?
I'll second it.
Okay, all right. All those who can vote on this in favor?
Aye.
Opposed? Okay, carried. Now, the next discussion is the projecting signs, and I gather we also have additional information on that. Maybe, Michael, you could walk us through what this is about. This was something that Julie distributed.
Yes, thank you, Madam Chair, members of the board. What you have before you is the copy of, I believe, the latest, the draft of the ordinance that was introduced by the Municipal Council. There's also graphics that will be included in the ordinance if it is adopted, just to be more customer friendly. There's graphics that show, that just better explain how the blade sign ordinance will work, the projecting sign ordinance will work. I was going to give you a little overview of how we got to this point, and then if you have any questions, please feel free to ask me. As you may recall, the Princeton Merchants Association, through the Mayor's Economic Development Committee, had requested that the municipality consider allowing this type of signage for businesses, particularly in the Central Business District. They're called projecting signs or blade signs. And the idea was to make our businesses in Princeton a little more competitive. It's signage is a very cost-effective way of advertising and marketing, particularly for small businesses. So the Economic Development Committee sent it to the Planning Board, this request to consider this change in our ordinance. And it was then referred to the ZARC committee to work on this, since it would be an amendment to the zoning code. And what happened was the ZARC working with representatives from both the Merchants Association as well as the Historic Preservation Commission, since that involves a large area of the downtown, and they're very concerned about the look of the downtown and keeping the architectural and historic integrity of the streetscape and the buildings there, all came together in a working group. And over several months, we came up with a draft ordinance, which was then, I believe the planning board has seen the draft or did see it earlier, and then it went to the council for review. So basically what's before you this evening is the ordinance that was introduced by the council on January 27th. And what it does is it goes through where these signs are permitted, which for the record, it's in the CB, RO, RB, NB, and SB zones of the former borough, which basically is most of downtown and most of the Witherspoon Street corridor coming out of downtown heading north. So that is what's before you. It's a straightforward ordinance. It covers where the signs will be located, the maximum size that's permitted in terms of area. These are two-sided signs because they project in a perpendicular way from the building so they can be seen up and down the street and sidewalk in front of the buildings. It talks about spacing so that one sign doesn't block the sign of a neighboring business. It talks about where the permitted location zone on the facade of a building, basically in the area of the first and second floors of the building. And you'll see in the ordinance it's pretty specific about that. It talks about appearance and materials. It goes into specification about lighting, different lighting options. So that's all contained in the ordinance. And the chair of the ZARC committee, I don't know if Jeffrey wants to say anything else about the ordinance that's before you.
I don't think, I mean, I think we talked about it before. I guess, you know, I guess the question is sort of what's new here. I mean, what's the issue that's before us today?
Yeah, there is one question that was raised by the chair of the Historic Preservation Commission regarding, if you look at the ordinance, you'll see that in one way to make these signs both effective but also to streamline the review process for them, because as you all know, time is money with businesses, and to help businesses get their signs up and to be seen, particularly for new businesses. The idea was that if the projecting signs are conforming to the ordinance, then they would go through, they'd be administrative waiver, be approved by staff. And they would not have to go, even if they're in the historic district, for the Central Business Historic District, they would not have to go before the Historic Preservation Commission, which would add time to the review. The concern was from the HPC that if a sign is non-conforming and it needs to go before the zoning board for a variance, they would like to be part of that review process. And we always intended that to be the case, that if it was a non-conforming blade sign being proposed that didn't meet our ordinance, then it would be certainly appropriate to have the advice and input from the Historic Preservation Commission. So that was the request. David, I don't know if you wanted to mention anything more because you sit on that commission.
I guess this is in the email that was printed out and given to the board members, but and since I wasn't present at the ZARC discussions about this, I don't know all the history, but there is, I mean, as a matter of course, in the historic district, a fully conforming building application that may make some modifications to a historic building does go to the Historic Preservation Commission. And so I guess the question is, what's special about the signs that would exempt them from that standard review?
I can address that in terms of what was discussed in this working group. The idea was that one of the major complaints we've heard, particularly from the business community, is that it takes a long time to get signs approved, particularly in the historic district. So from the very beginning, when this working group came together, an idea was to how do we make this happen faster? And that's why we spent so much time on the design guidelines for the signs, so that if you can do a sign that conforms to these guidelines, you shouldn't have to wait for approvals. That was always the intent of the group, of working group. And I don't know if Jeffrey wants to add to that. But that was certainly-
NHPC was represented
Yes.
in those conversations?
They were.
Okay.
So my suggestion would be tonight, I think if we just add in the section of the ordinance that talks about that, let me see what section it is. It's page 3, under, it's the top section number 1, but it's section M, where it talks about projecting signs in historic districts. I think if we just add the word conforming at the beginning of that sentence, then the only time that there isn't review by the Historic Preservation Commission is when they're non-conforming. I think we would take care of that.
I'm sorry. Can you read section M, because I don't have it in front of me. I'm not sure if
Should I
everybody
read it
else
with the
has it.
language I'm proposing? Because I'm just putting in one word. Well, right now it reads projecting, let me take my glasses off. Projecting signs in historic districts or historic buffer districts shall not be subject to review by the Historic Preservation Commission or the Historic Preservation Officer. So what I was recommending is that if we add at the beginning, say, conforming projecting signs in historic districts or historic buffer districts shall not be subject to review by the Historic Preservation Commission or the Historic Preservation Officer. That way, anything that doesn't meet this new ordinance would be reviewed by the commission. Because they've had input into this ordinance, so they agree that this, the ordinance, if you conform to it, then it should result in appropriate signs for the district.
Yeah, I mean, unless I'm misremembering it, I think that with your change, that would make it what we talked about it was supposed to be. I mean, I think the idea was that with everybody's input into the design guidelines, that would give businesses the opportunity to look at those design guidelines and say, hey, I can do all these things.
Right.
And pick what makes the most sense. And if they have to do something that's outside of that, then it's reasonable that this review would occur.
Correct.
Yes, Michael?
Michael, oh, I'm sorry.
Could I just ask, Julie's memo was concerned about that something about the application for historic preservation review. Now, and while review by the Historic Preservation Commission or the Historic Preservation Officer, but that they should not even have to put paperwork in of any kind? Am I reading that wrong?
My understanding, it was this concern that the Historic Preservation Commission and staff would be left out of any review and having input into projecting signs that are non-conforming. That was my understanding, and I think we can address that this evening.
Since this is coming back to us for conformity with the master plan, is
Right.
this is not a substantive change?
No, it is not.
Were there any other points? Yes.
So would the Historic Preservation Officer be included in the administrative review as of course with a sign that was conforming, that met all the design guidelines?
Yes, that was always the intent, and that was discussed during the work sessions. She would be, the officer would be part of the review team.
All right, thank you.
Michael, is the wording that's in this email, which I think says exactly what you, or substantively what you just proposed, but I think reads a bit more clearly? Have you seen this?
Yes.
Is that the wording you mean to put in there, or
Well,
is
that
it different
was
in some way
suggested-
that I don't understand?
I believe that was suggested by the chair of the Historic Preservation Commission. And I think it accomplishes the same thing if the board is more comfortable with that, with that wording as opposed to my suggestion of putting it up front. I think it results in the same meaning.
I just think conforming projecting signs is less clear than projecting signs that conform to the criteria.
Absolutely.
So
I'm fine with that. I think you're right. I think it just sounds more clear.
I mean, if you're a planner and accustomed to reading ordinances conforming this and conforming that,
that would be fine.
But people might misinterpret it as a verb instead, or whatever that is,
Yeah.
gerund?
No, I think that accomplishes, I think that addresses the concern.
Okay.
That's fine.
Thanks. Thank you.
Right. Well, I'm still a little bit concerned about, the whole idea was to simplify the process, so I like Julie's suggestion that shall not require an application, which is paperwork for historic preservation review, or review by the commission or the historic preservation officer, that it wipes out all three of those points. Now, is that what we've got here now? I mean, the first thing that takes a lot of time is you fill out the forms, and then somebody has to determine whether it's conforming or not. And if it's not reviewed by the commission or the officer, how does it get determined as being not conforming?
Well, I don't know, Derek, if you want to, maybe how you envision including the historic preservation officer in the staff review.
Yeah, I mean, they would
address
file a sign permit. Elizabeth and I would look at it and process it as a sign permit. And if there's an issue with it, we would address it at that point. But, I mean, if it's a non-conforming sign, HPC would have a place at the table when they write a memo for whether it goes to the planning board or the zoning board. So this just is an attempt to try to move the process along a little bit, but I'm happy to work with Elizabeth. She's a good asset, and I think it's an improvement to the existing situation, and it gives businesses another opportunity to advertise, and I think we need everything to help businesses in this environment right now. So,
Any other comments on this?
Not a comment. If we are being asked to take action, I would move that we approve it. Approve the amendment. But maybe you need to take public comment first. I don't know.
Is she here? Elizabeth, could you come up to the microphone? How many of you know Elizabeth Kim, the Historic Preservation Officer? And just...
Elizabeth Kim, Historic Preservation Officer. Just in support of the wording that you have in front of you, I think that what happens is that it has the opportunity for the Historic Preservation Officer, myself, to be able to review it with Derek, as he had mentioned. But when you have the other wording where it says it will have no review by the Historic Preservation Officer, then there's no opportunity to make sure that it conforms. So I believe that that wording actually simplifies it and allows that opportunity for it still to be, streamlined as far as the review goes.
So, any comments, anybody? Well, we have to choose one version, so somebody...
Madam Chair, I just wanted to be clear, since I made the initial proposal, I'm perfectly comfortable with the wording for Section M as proposed by the chair of the Historic Preservation Commission. Just to be clear on that.
Yeah, I think as just described, it makes sense to me that we could use that wording. I think that's, again, I think that reflects the spirit of the conversation we had in the ZARC committee.
No, she sent it on, but this was written by Julie.
So should I move to approve with that wording?
Thank you, Jeffrey. Is there a second?
Second?
Okay, it's been moved and seconded. All those in favor?
Aye.
Aye.
Eileen.
Have to what?
You'll see they were actually generated by one of our architectural firms that was part of the working group. And what we plan to do is insert them into the ordinance just to give, more of a illustrative aid so people understand some of the points of the new ordinance. So you may want to just acknowledge that you think that they should be incorporated into the ordinance.
Does somebody want to move that?
I will happily move it. I think it's always helpful to have illustrations. I'm a big fan of illustrations.
I'll second.
Is there a second on that? Thank you, Tim. Okay, everyone in favor?
Aye.
Opposed? Okay. And this will go back to council with the notation about the change in the ordinance as far as HPC, and perhaps with our thanks for the contribution of the drawings as well to the architectural firm.
Madam Chair, I'd also like to take the opportunity to echo some of the comments made by the mayor on the 27th of January, that the Historic Preservation Commission deserves a tremendous amount of gratitude, and we should commend them because they really stretched in terms of, they have legitimate concerns about preserving the integrity of our historic district. And this is a new direction in terms of signage. And signage is obviously visible, and it has a visual impact on the district. So it was a coming together of the business community and our advocates for historic preservation. It was really a wonderful working group. I also want to thank the ZARC chair, Jeffrey, for bringing this group together, and I think we really came up with a great ordinance.
Okay, let's move on to the next item. This is Landwind Development Corporation. This is carried from December 5th of last year. It's preliminary final major subdivision and site plan with variances, asking for revisions to the findings in relief of a condition. It's Province Line Road, Block 102, Lots 602 and 1802. Okay.
Hello?
Excuse me, is your mic on?
This is Stephen Griegel, attorney for the applicant from the law firm Roselli, Griegel, Lazier, and Lazaro. I want to thank the attorney and his firm and the professionals who have already spent some time on this with us. And ultimately, after going back and forth and spending some time, they said go in front of the board and present everything in an open forum, which is what we did. We gave the public notice, did everything we had to, and here we are. The documents I'm handing out are really just things that are already part of the record. It's not going to be anything new, but I hope it'll just streamline what I have to say and make it easier to understand where I'm coming from. The way we got here. Okay. So the way we got here is if you look at Exhibit A, which is the resolution in this case, and you look at page 10 of the resolution, that's what we're here about today. You go to page 10 down to paragraph C. Our request is that we get relief, that we either strike or get appropriate relief with regard to the sentence that says the developer has indicated that the proposed dwellings will be one-of-a-kind custom designed structures. And that's the language that we're proposing be taken out. As a background, what happened is sometime after we had a purchaser that was interested, it was brought to our attention this language actually existed in the resolution, and to the applicant that was a surprise. Now normally that wouldn't be a surprise because it was located in the resolution at the time it was reviewed, but that's just a fact that it was. So we did some work and we tried to find out why, where this came from. What we asked our clients, we asked the attorneys, and the first thing I did is I went online and I looked at the one hearing this matter. I watched the video, and I also looked at the the transcript. This transcript is attached, the important part is Exhibit C, attached here too. And what I found was that within the transcript, there was never, not in one place, any intimation or mention that the buildings would be one of a kind or would be custom home. In fact, the word one of a kind never shows up in the transcript at all. So I could tell you that I'm 100% positive that that was never discussed or ruled upon at the one hearing we had. I have included, though, in Exhibit C, starting on page 44, is the one mention of the word custom, because there was discussion about something being custom, and it's crystal clear from pages 44 and on that discussion was raised by someone on the board who was concerned about the grading and how the plans relate to grading and tree protection on the lots. And they were talking about minimizing impact to the environment, which the resolution made finding that we did. And the individual from the board even said we want to do something more natural grading, and I'd like to get your reaction to that idea. The applicant's engineer responded, and this is the one time custom was mentioned in the entire transcript. Mr. Brown said, right, well, we're expecting that each of the individual lots is going to be subject to a probably custom design. So the fact that this wasn't ruled upon or discussed in the hearing is something I think is important, because then we had to dig deeper and say, well, if my client didn't believe this was part of the record and was surprised later on by it, where did it come from? When we started talking with the board's counsel and emailing back and forth, what they said is, why don't you take a look at the Princeton Environmental Commission report, which is attached as Exhibit D from 2018. So we took a look at that, and Mr. Muller's partner pointed out to me, which I've circled, the last page under general building. She said, well, look, it says right here, the developer has indicated that the proposed dwellings will be one-of-a-kind custom design structure. And that's language right there that it looks like was pulled from there and put into the resolution. And so I'm thinking, well, where did that come from? It didn't come from any ruling by the board. It didn't come from any discussion during the time there. So I looked further, and lo and behold, Exhibit E, which is a prior version of that report, same report but prior version, had a little bit different wording. It said under general building, it said a note on the fire protection plan serves as a disclaimer indicating that each proposed dwelling will be one of a kind, a custom design structure. So there's that language that they say came from the only place in the record that I found where that came from, and I looked, was if you go to Exhibit F, that's what it refers to, is a plan for Provincine Woods Phase 5. The second page of that, lo and behold, the culprit is there. If you look on the fire protection plan, it has a specification. It says proposed dwelling note, and this is why I think it came from there, is not only because it was mentioned in the report, but it says each proposed dwelling will be one-of-a-kind custom design structure. Now it really doesn't belong there, as it's on a fire protection plan, but that's the only place, and it was never discussed, it was never ruled on, or the like. But that right there, I'm telling you, if I had my client testify, who's here today, they would say, look, they were surprised that that wasn't supposed to be in there. The engineer would say that was a remnant from a prior version before these lots were clustered. So they were willing to put that on there when the previous application that was ultimately withdrawn, before it was clustered, the lots were much, much bigger. So with my client's position that wasn't supposed to be there, they missed it in the resolution, we started saying to ourselves, well, how do we fix that? And the reason that we needed to fix it is because there's a few reasons. One is the law. Okay, it shouldn't be in there by law, absent our consent. And aside from the law, practically, it proves to be impossible to put into practice. And the way this happened was when the proposed purchaser went into the township professionals and the township attorney and said, look, this is what we intend to build. What's this one-of-a-kind custom? What does it mean? And what happened is the professionals, they could testify exactly what they said because I wasn't there, but my understanding was they each felt differently about what that might be. And so it raises the specter of what is custom one-of-a-kind. Is that something that can actually be legislated and decided fairly? For example, if they came and built a home, say they have 5 model homes, 6 model homes, and they came in and they put one of their model homes up in lot number 1. Because the way this process works is each home, to build it, they have to go get the permit from the professionals, and they're the ones who are the gatekeepers of if these houses qualify. So any purchaser that we're going to get who is going to build out the project is going to want to know ahead of time if they're going to be able to build a project. If their homes aren't going to qualify, we can't sell it to them. So without a definition, without us being able to tell them, or the board being able to tell them what custom homes is, we're not going to be able to sell it. It's going to be very difficult to sell the property. And so practically it's a problem for us. It's a problem for anybody who wants to purchase. It's probably a problem for the professionals who have to make decisions under a word that is ambiguous. So for example, one person might say, well, obviously a custom home means you get your own architect and you build it out, and you've never seen anything like this before. Another person might say, no, if you have houses that are somewhat similar, but they're all changed around because everybody who comes in and makes selections and does this, and by the time you're done, and it's not on the same flat surface, and it fits in with the landscape, well, that's custom. You might have somebody from the public say, I want to have custom homes, and they might have a different opinion. You might go up to a court, which nobody wants to go to, and we're like, Judge, try to determine what custom is. And what we're going to find out is that it's ambiguous, and what it does is it just creates conflict and problems that we don't want. And one of the things I want to stress is this project, if you go back to the 5 phases, it's been going on since this town's had a relationship with my client on just this project since 1988 at least. It's been going on a long time. They've come in, they've done things for the town as far as changing their applications for the board. They even clustered this where they got some more units, but 75% of this is going to be preserved. So they've been trying to cooperate, and what I'm trying to do is come in and say, how do we solve this problem? Because it's going to be a problem one way or another for us, for the professionals, and for anybody who tries to purchase it. So that need, it's a need, and it's a real reason that we're here today. We're not trying to just come in and say, we're changing what we thought was in there, or we're trying to pull a fast one. We're coming in because my clients didn't notice it, they didn't see it in there, and now we have a real need. And we were trying to find the right procedure to address it. First, we came into the procedure of talking to the attorney and the professionals. Now we're trying this via amendment, which we think is the easiest way. We're trying to streamline it to save money and save time and all that. Other procedures we could think of, I don't know, filing a new application, filing an amended application where we take this language, this offensive language off, and just taking that right off, right? File the same application, and there we'd be in without that accidental language in there. But we think, and we've tried to express it, we think that's a waste of time and effort for everyone involved, the board, us, the professionals. And so we were hoping that this is the most streamlined and fair way to make our presentation. The reasons why we think it would be appropriate and helpful to everyone involved, including the board, to address this today and hopefully give us relief is, first of all, the law, the way the law reads. It all builds off, I think it builds off, it starts with the state constitution that says everybody has the right to own, to protect, and sell and alienate their own property. And in fact, the Supreme Court has ruled many times that restricting the alienation of property is frowned upon in New Jersey. And when you build off that and you go to, you can see that's how the land use law was made. If you go, you don't have to read through the whole thing, but I just put it in there. Exhibit G is a land use law about what ordinances can say, the contents of a zoning ordinance. Nowhere in that zoning ordinance do they say that you can control the aesthetics, the architecture. They list out what you can control, but they never say that you can control the aesthetics and the architecture and the like. And this was actually recognized in Princeton's ordinance. So it built all the way up. It built from the Constitution up through the state statutes, and it's in the Princeton ordinance, the one that's relevant, the exact one that's relevant to this case. If you go to Exhibit B, this is the section of the ordinance. It's actually cited right below that language in the resolution. The resolution says one-of-a-kind custom home. And the attorneys will say, well, we put that in there because it was on your fire plan. And that's where we grabbed it from. But below it, or above it, it actually then uses the language from the ordinance, which we fully agree to comply with. And it's important that if the relief is granted that we're seeking, we intend and want to comply with every rule in every ordinance of this town. We just don't want to have to do more accidentally. So above the portion where it says, and this was in the ordinance too, proposed structures shall be related harmoniously to themselves, the terrain, existing buildings and roads, and historically significant features, and on and on. So it talks about how the buildings are going to relate to the terrain and to each other, but it doesn't talk about the sticks of the building like this custom one-of-a-kind would. And they say, okay, well, that's the ordinance requires you to be related like that, and that's in the resolution already, so we don't need to draft anything else, and we agree to comply with that. But up above, the people drafting the ordinance for Princeton, in the first paragraph, where I underlined it, said, neither the committee, commission, nor the planning board shall specify or favor any particular architectural style or design or assist in the design of any building submitted for approval. Participation by the committee and the board shall be restricted to a reasonable professional review, and except otherwise provided in the following subsections, which we cited, full responsibility for design shall be retained by the applicant. So the point I'm saying is what I believe that the law is crystal clear and very clear, and it's been well established in New Jersey and in Princeton, that unless we have a situation where we consent to build one-of-a-kind custom homes, which arguably it's part of the record, although we think it was accidental and was just on a fire plan, unless we consent, this board would not be able to write that into a resolution. We think that is very clear law. It's right in your ordinance. And so we think that if we had to take the extra steps and go make an amended plan or a new plan, which would be uneconomical and time-consuming and waste everybody's time, we think that the board, if that language wasn't on that fire plan, the board couldn't make us do it. So what we're asking is because this is something that the board can't legislate to us. Okay, you can legislate all the things it has, and we're going to comply with that. But because it can't legislate to us if we don't consent, and if it's not practical to have it in there, because if you have those words in there, as I said, there's going to be all types of disputes. It's going to engender disputes, maybe litigation over what custom homes means or if we've satisfied it, and it's going to really make it impossible. It's going to restrict the alienation of the property. But, besides that legal argument, it's just going to make it tough for everyone, and that's not what my client wanted or intended. And I recognize one of the issues that came up I know is coming up, is we were asking, well, what did the board think? Did they think? Because they never discussed it during the hearing. And when I first read the transcript, I said, well, did the board really think it was going to be custom, or did that just get inserted? I don't know that for each individual, what each of you believed at the time or what you based it on, and that's for you to say or just to know. But I wanted to point out those parts of the record where it came from, because I wanted you to understand and take our word for it that that's how it happened inside our fort with my clients, is they just, they didn't see it in the resolution and they didn't know it was on the plan, and that's why we're trying to get relief in the easiest way possible. So, So what we're asking is that it be stricken so that we don't have to take harder, tougher procedures and more applications that we think are not needed, because this board does have the power today to hear this. That's why they're hearing it, and they do have the power to, they retain jurisdiction of these things as they go along, and they have the power to amend a resolution if they think that it's appropriate. So for those reasons, we'd be happy to answer any questions. But for all those reasons, and for the fact that we're really trying to fix a problem, a real problem, we've been trying to cooperate over the years, and it's been a long go. We're just asking if the court would consider that, and if they do agree that that's what the law is, that ultimately you can't legislate that the homes be custom and one of a kind. And if you do agree that we didn't want it that way and that it's going to cause problems, then we would ask that you be agreeable to fix the problem tonight and allow us to move forward. And you know, as moving forward, it won't change anything else. Still, every house is going to have to be submitted through the professionals, through their design, and that process will continue for each lot. What it will do is enable us to sell it. It'll enable us to move forward and sell it without further hearings and the like. Thank you.
Okay, questions?
I guess I wanted to not so much ask questions as respond to a couple of the points that you were making. First of all, I think I'm the unidentified board member who is commenting about the preserve because I really love that development, and I don't know if you took a look at it, but it is, I mean, it may be a little bit subjective and hard to define custom one-of-a-kind homes, but that's certainly what they have in that development. And they're quite close together. I can't say for sure that it was a cluster. When it came before the board, that was before my time, but they're not 4-acre lots, that's for sure. The one point that I wanted to make is that I don't think that the definition of custom one-of-a-kind home is any more subjective than the requirement that each lot be designed with sensitivity to the existing grades and in an individual way. That's going to be just as much subject to the interpretation of the staff who are going to be reviewing these individual plans. So I don't really feel like that holds water as an argument saying it's too subjective to enforce. I think that while we may not be able to define exactly what custom one-of-a-kind homes are, we all know it when we see a development with repetitive buildings that are cookie cutter or maybe mirror view images or the same building with slightly different finishes. You see those all the time, and I think that that's what we're trying to avoid with this language in the resolution. And I guess the question that I would ask is, rather than striking the language, whether you can suggest a modification of the language that you would be able to live with that would help us avoid that outcome of, the same models being used throughout this development in such a way that it will really not fulfill the goals of the way the resolution is written right now.
One of the problems with that is it may depend on the builder, and I understand what you're saying about the subjective nature, but the one thing is, just because of the location of this and the clientele, that the amount of money that someone's going to want to receive for the property and the clientele, they're not going to build houses that are junky. They're just not. Now, for example, if someone comes out, like you say, that has 5 models or 6 models or whatever, and they look similar, but they're not the same. It's interesting because when you think about it, so you go out with the first house that's a model, and you apply, and then the engineer or the building inspector says, well, this is the first model, so even though it's a model, I guess it's unique, right? Even though, I don't know, is it unique if they built the same model in Maryland or not, right? So you build the first one, then a second person comes along and they build the second model, and it's a different model, right? And it's difficult. I understand what the board is saying, and frankly, I understand why people, as people, might want custom homes. right? That's not lost on me. Everybody would like something to be the most beautiful or different or aesthetically pleasing that they want it. What I'm trying to say is, even though that might not be that may be everyone's druthers, is even if you don't agree with my argument about the subjective nature, we've been trying to drive that home because I think it's correct, but because it was so problematic right outside the gate. But what I'm trying to tell you is maybe this answer isn't the best thing that the board likes, but I'm trying to tell you that I think it's very clear that if we refiled or did whatever we had to do and struck that and said we won't agree, we'll agree to everything that's allowed by the Supreme Court, that the municipal land use law and this ordinance, and we don't want people being our architects or being our aesthetic people. I think that it's clear that that's our right. So I know that's not the way the board wants to hear it, but that's actually what we're asking, because what we're saying is if you do say custom homes, which we don't think you're allowed to do, it's going to make the property very, very difficult, if not impossible, to sell in this particular situation.
Look, can I follow up on that? Because
Yeah.
I think, your point is maybe well taken about custom homes, but I think just to build on what David was saying, if you read the transcript down below the part that you underlined, your underlining says, we're expecting that each of the individual lots is going to be subject to probably a custom design.
Right.
And they continue to discuss the fact that there's value in focusing on the grading in a way that's consistent with the environment in a separate way. And then if you go on down, the unidentified speaker says, yeah, I guess if there's a way to do so, I'd like to impose a condition that we try to do that. Mm-hmm. And then that continues the conversation. So I guess the question is, if you're coming to us and saying you just want to take this language out, is there something that remains in the approval that would require that aspect of it? Like, if we're not telling you that you have to custom design every home, but we are saying we want to maintain that, which is clearly asked for in the transcript, like, where does that remain if you take this out?
Yeah, we don't have a problem with that concept. And in fact, I think that's what my client thought was going on, right? Was that these lots, because we understand that the ordinance says, look, all the homes have to fit within this landscape, and we know that Princeton has an interest in keeping it the most natural that it possibly can. We don't know exactly what that means, but as far as placing the houses and doing the earthwork and the like, our builders, we think, need to satisfy that in keeping with the language of the ordinance. I think the language of the ordinance talks about the land and the landscaping, how the houses fit within each other, and says, look, that is customization, because it kind of gives a definition of how they want it to be customized, and it's like this. And when there's different elevations, and what we thought is, anyway, if you're trying to get some flavor to the neighborhood or keep the things just look like they belong, even if the houses aren't as custom as the board would like, just having them on different elevations, right? Because it's up there and they're going to have to move things around. They're not just going to be all on the same elevation. There's going to be some differential there anyway. And I do believe that the language of the ordinance is what this is. And I think that we do have to comply with that.
So what is that language?
If we go to Exhibit B, I think the language is we would have to comply with this ordinance, this whole ordinance, but the part that's in the resolution is the part I circled as C, relation of proposed structures to environment. Okay, and they have to not only be harmonious to themselves, the terrain, the existing buildings and roads, and historically significant features, and it goes on. The achievement of the harmonious relationship may include the enclosure of space in conjunction with other existing buildings or other proposed buildings and the creation of focal points. It goes on. So it's talking a lot about terrain, how they relate to each other, keeping everything harmonious. And that's something that is an ordinance, and that's something that we have to comply with. And I believe that maybe what the transcript was talking about that subject matter. And if what they're saying is we want to make sure there's a a check and balance to make sure that that happens, that nobody's just going to come and make everything look like one box next to the other, and it's going to match with the terrain and all be harmonious with each other. That's in there, and we agree that we have to comply with that. I hope I said that right.
Let me try and create the framework for this. And first, to explain what a resolution memorialization is, that it's findings of fact and conclusions of law. That's the rulings by the court, by the board. That's the decisions by the board. A board, in fact, doesn't have to be discussing X, Y, and Z, and it could, if it's in the resolution and the board approves it, that's a finding of fact or conclusion of law. And in fact, the case law makes it clear the board doesn't even have to deliberate. But once there is a resolution that's drafted and voted upon, that's the decision of the board. So the fact that the board didn't rule on a couple of items that Mr. Griegel related to really is completely irrelevant. What is necessary in a resolution is that there be support in the record for it. And with respect to this finding about custom design one-of-a-kind houses, which is really the basis of the board finding in terms of the harmonious relation to the environment, there's several places in the record that supports it. We've talked about two of them. One is the testimony by the engineer, Mr. Brown, and the second is the PEC memo. Now, there was a prior PEC memo in 2017 that Mr. Griegel refers to. That is not part of the record. The only PEC memo that's part of the record is the one that talked about custom design one-of-a-kind houses. So you had that, you had the testimony by Mr. Brown, and then you had a second place in the record where Mr. Brown said, and there was a discussion of trees at this point, and he said a number of trees will be removed for the road, additional clearing. There will be additional clearing, as Jack mentioned, for each of the lots when the individual homes are sited and designed. So it certainly, I think one can take away from that the concept of the owner at that time was that, in fact, these would be custom designed one-of-a-kind houses. Now, Mr. Griegel indicated that he wasn't at this meeting where there were professionals, but Jack was there and Derek was there as well. When we talked about this and to see whether we could come up with a better definition, and we couldn't, but it wasn't that each of the staff members had a different interpretation. In fact, all of us had the same interpretation, which was, seems clear to us. It's you get an architect or other designer design the house. That's basically it. We're not trying to control the architecture. We're not trying to control the architectural style, but we're requiring that they be individually designed houses. Now, the other people at the meeting were a series of people from Toll. They were the proposed purchaser. And the 5 or 6 models that Mr. Griegel is referring to are the Toll models. And at least the thought of the staff was this was exactly what the board did not conceive of at this development. They conceived of something that related much more closely to the environment. So I just wanted to put that all in context.
Yeah, and if I could add to that, first of all, I've kept saying this, and I don't know why myself and Mr. Mueller can't agree on one point, because every time I read the transcript, I see talk about trees and I see talk about the landscape, but I don't see talk about the sticks of the house. And so I don't know why there's a difference of opinion on that, but you can read it for yourselves. But the issue that he's correct about it is the legal kind of stance of this is if we can't we're trying to get relief in the easiest way possible. And right, if this is in the resolution, right, it's written in the resolution that it's one-of-a-kind custom homes, and it was missed, and that's the way it is. And what I'm saying is, yeah, fine, if we try to say you're wrong about certain things and go to court, the court might ask us the same question. Well, isn't it in the resolution, and don't I have to keep it there because it was part of the record and nobody made an objection when we were looking at the drafts? I understand that. What I'm trying to say is that there's other paths. This is a path today to get there because the other tools that we have available to us, and this is what I've tried to say, is if we want it out of the record, we're letting you know that that being on a fire plan, because that is where it came from, and the fire plan's part of the record, is you can see that it wasn't meant to be there. We've said it wasn't. So our only other option, aside from going to court and trying to convince a judge why it was there and we missed it, is we could file an amended plan, and it would be entirely the exact same application, the same one, and we would literally have somebody erase that. And then we come in and say, do we have to start all over again? What do we have to do? That's the real life practical problem that I'm trying to solve for my client. And that's the reality. We're throwing it at you exactly straight of what it is, and we're trying to solve the problem. So maybe that's what we do is we come in and amend it, but we're saying if the board knows that we can do that, and we know we can do that, why are we doing that? Why don't we decide today if we could take that out, because the board can't legislate one of a kind when it says it in the ordinance and when it says in land use law. You can't do that. If we come back in and strike it from the record on the one spot where it wasn't supposed to be, and it's obviously out of place there, and then we apply, then we're going to have a clean record. And if the board takes the same position and forces us to appeal because we believe we're right, we're not trying to be litigious. We're trying to solve a real-life problem. If we believe we're right, then we go to court with a clean record where we didn't consent to it at all or we didn't miss anything. And we're saying, why take that step when it's clear? I think it's clear that's what the law says, is that you can't legislate it unless we consent, and it will cause problems. We're not going to be able to sell it to people who are going to want to build the houses because they're not going to know what they can build. And it's not practical to do it the other way. And you know, they came in, you know, they've been doing this a long time. I think they had an application in 2011. They did it without the cluster. Then people wanted us to have the cluster. So my clients, before my time, they came in and they did the cluster so that they could get access to a different place, and it was the way everybody wanted it. And what we're trying to do is through all this time, solve a real honest problem that we have in a way that we think is consistent with the law, will save time, and will not prejudice anyone according to what the law says, because we agree to follow all of the laws and ordinances of the township. And that's been our position, and that's what we're saying. That's as straight as I can put it.
And just to add 1 or 2 points, obviously I disagree as to what the law provides from what Mr. Griegel says, but hopefully we'll never have to have that resolved. The fire protection plan from 2017, that was never part of the 2018 record. I just wanted to make that clear.
I had, I thought I pulled this off of the, that's why I put the first page on. And I thought it was part of the plans because the first page of this set says Providence Lines Woods Phase 5, and it was this set. So, but the language is exactly the same from the ordinance and in the thing, so it's clear where it came from. It's the same language. So I at least wanted to show the genesis of that. It's not, but what I'm trying to do with that is show credibility to the fact that my client was surprised about it. I don't want you to come in and think that we believe we told you this 20 times in some other place, and then here we are, we're trying to switch. I just want the board to understand that from our perspective, there was a fire plan, and we didn't know that it was in there. That's what my client would say. And that when we discovered it, and when we discovered it in the resolution, it was a true surprise to us. It caused a true problem. And I want the board to understand that, at least from a credibility issue.
But there was also a statement by the engineer during testimony representing that they were going to be custom one-of-a-kind homes. It wasn't just on the fire plan.
That's right.
I've read it so many
times. It was
times.
not just on the fire plan. And I mean, I hear your multiple references to litigation and, you know, setting those aside, what it sounds like you're doing is asking us to just change our minds when what we talked about and deliberated over had to do with exquisite sensitivity to these lots in a very environmentally sensitive area of town, and absolutely not wanting to see a bunch of houses up there that were variations on a theme. And it seemed to be really clear at the time what the board wanted, and it seemed that the applicant was entirely comfortable with that, and then it was in the resolution, and they never objected to it then, and I would push back hard against the suggestion that we're trying to favor a particular architectural style or a particular design. We're not. At least I haven't heard anyone suggest that we are. The point is for each home to be built carefully to the site, to the lot, to the environmental constraints, and that there's a beautiful end product.
Okay, and I would just ask that if anyone could tell me on 44 and 45, because that line says, after we're talking about the how the grading is going to be, because it says grading and trees, and he says we're expecting that each of the individual lots is going to be subject to a probably custom design, and in a discussion about grading, it's not talking about the sticks of the house, and you can all read it and make up your own minds. But when you say that you're not restricting design, you are restricting design. Although you may not be saying that I want this particular design, you're restricting design, and you're restricting alienation, and you're restricting architectural designs that someone could bring.
But the ordinance says specifying architectural style or design. It does not say doing our best to make certain that, you know, the site and the lot and everything is designed in a sensitive way, and that there's no expectation or suggestion, and certainly not desire on the part of the board, to see Model A, Model B, or Model C with the garage on this side versus that side, and do you want the siding this color or that color? Do you know, I mean,
Yeah.
I think
I understand that argument, and what I'm fundamentally
clear
saying.
at the time, and is reflected in the record.
Yeah, and what people believed or thought the intentions of the other people were at that time, you're right, I wasn't here. But what I'm saying is, even with that description that you just gave, that we won't allow different models, there are variations on different models for there to be a neighborhood of 19 homes. What I'm telling this planning board is we strongly believe that you don't have the power to do that. And you don't have the power to say it has to be one-of-a-kind custom homes. Okay, I recognize in the one that's pending before you right now, yeah, there's language in there where we said it, so it makes your case stronger for this one. But I'm saying if we had to jump the next hoop and do it, I'm telling you, my firm and the applicant, we strongly believe that you don't have the power to restrict design like that, and to tell potential buyers who want to buy that you can't do it that way. They have to be one-of-a-kind custom. That's what I'm saying is a restriction that doesn't fall within the law.
Go ahead.
Yeah.
I have a question more than a response, because I didn't participate in the hearing before. So I'm just wondering, Jerry, my understanding is when the board issues a resolution, and the applicant doesn't agree with something in the resolution, typically they have two choices. They can accept it as is, they can appeal, right, to court.
Yeah, I mean, it's really a third option, which is frequently then they get back to the staff and they say, you know, everything's fine except can you change X, Y, and Z? And in fact, there were a lot of comments that were made by the attorney for the applicant at that time, and I believe a number of changes were made. And that's a typical process that goes on. But if they're not satisfied with that, they can appeal.
But that's not what is happening here. This has been...
Not with respect to this language.
And so has the relief that the applicant is now seeking ever been sought or granted by this planning board in your recollection?
You mean modifying a different finding of fact and conclusion of law?
No, just, it strikes me that what the applicant is asking for procedurally is like a mini appeal.
I'm sorry, I didn't catch the word.
It's like a mini appeal. I'm just using that colloquially, but I'm just wondering whether there exists any kind of statutory authority for the type of de facto appeal that's being sought right here.
There's no statutory authority, and there's no direct case law, but there is case law that says a board can reconsider an approval if there were errors made, if erroneous information that was relevant to the decision was made. That kind of is the closest, and it's really not quite on point.
Erroneous information that the decision was based on,
Yeah.
but not a disagreement necessarily about interpretation of something in the record.
Right.
Got it.
Jerry,
sorry.
Can you clarify that, Mr. Mueller? Because I think the board does retain jurisdiction. I think in many circumstances, if the board finds that the interest of justice would require, because something comes up, that they do have the authority to make a change in a procedure like this.
I don't have any problems with this procedure.
Okay, procedurally, I just want to make sure we're on good footing.
So Jerry, sorry, you've said in the past that there is case law about regulating the architecture. Could you clarify about that?
Well, there's actually statutory law that says in the context of historic preservation districts, you can have architectural controls. Absent historic preservation districts, I don't believe you can. But we've done a little looking at that. We couldn't find any case that was on point. So at this point, my opinion would be we wouldn't have the power to do that. But obviously, it's not that we have an ordinance here that has a series of architectural controls that govern outside the context of historic preservation districts. We don't. And it's not that we've imposed a condition that says this is you need to use the Bauhaus style of architectural control, or from the Frank Lloyd Wright Prairie style. We haven't done anything like that.
In my opinion, again, on that is if you're restricting the architecture so much by saying one-of-a-kind custom, that is a restriction on architecture. It's pretty clear in my humble opinion.
No, in fact, it's an invitation for architects to be as creative as they can be, given the environment they're working in.
You're saying that if people come with their architectural designs and they're similar, that you're not going to allow it, and that's a restriction.
But if it's in the resolution and everybody agreed to it, I mean, whether or not it was a mistake, I mean, isn't that the decision? I mean, and that's even if we can't regulate architecture, they agreed to regulating their architecture.
Right.
I mean, even though it's not regulating architecture.
I think the board can reverse it, but I think the board is on solid ground for maintaining the language that's in there now.
Yes, David?
So,
Go ahead. I've already had a turn. You can.
listening to my colleagues there, the board did consider the custom design, actually debated it and talked, did they consider that at all? Are you saying that that's?
I think we considered it. We did not debate it. Basically, if you look in the record, and as I said, I think I was the unidentified board member who spoke about the preserve. I certainly had custom architectural design in my mind, as well as custom grading and protection of trees and all the things that I mentioned in there. I did want to speak real briefly to what the interpretation of the engineer's words might mean. And I think that I would dispute your interpretation, even though he's talking about the individual lots rather than the individual houses. The site plan that was presented had very uniform grading on all of the lots with just standard pads being created. That's what I was reacting against. And so for him to say, well, we envisioned individual grading all along, that it wouldn't have made any sense for them to submit the plan that they did. So I think that he must have been referring to the design of the homes when he was referring to the individual custom design, even though he says, these lots would be subject to custom individual design. I think he was referring to the structures.
And just to go back, and let me read again a different part of the transcript where Mr. Brown is speaking. And he says, and again, he's talking about the tree clearing. He says, there will be additional clearing, as Jack mentioned, for each of the lots when the individual homes are sited and designed. I mean, I think that's even more explicit.
Yeah. I mean, the way I'm hearing the legal back and forth, I think if the applicant were to appeal this resolution, they really wouldn't have any success. I think we're on very strong ground that this resolution had full review and it was commented on, and this change was not requested, it was accepted. I think the only recourse for the applicant is to come in with a new application, deny our request for custom designed homes at that time, and then if we turn them down, go to court at that time. And I guess I would ask Mr. Mueller, in that sequence of events, what would you anticipate the court would say in that second go-round?
Well, it depends on what the board does in the second go-round. I would expect, frankly, that the staff would recommend the same type of notion that's in the resolution now as a way of dealing with this very sensitive environment that Louise referred to a few minutes ago. And we have an ordinance. One of the provisions that we have to show is satisfied is that the buildings relate harmoniously to the environment. And I think this is a solid way of showing how they relate harmoniously as opposed to a tract development, for example.
So if we have to, we're hoping to save a step. Obviously, I represent an applicant. We want to save money, and if that's going to be the legal issue, is where you think your ordinance, it says the buildings have to relate harmoniously to the environment, and if this board is going to say that means one-of-a-kind custom homes, we think it's our opinion that you're wrong. And I know you have your own attorney, but we don't think that a board should be even legislating like that because it's not what the law says. And you shouldn't be requiring builders to come in and telling them that they can't build homes that are beneath someone's personal desires because they're not one-of-a-kind custom. So I think we've said enough on our position, and I understand the board's position, so unless there's anything else,
yes,
that's what we say.
What I'd like to do, I don't know how many people here came to hear this particular item, but let me open the meeting to the public. Is there anyone here who wants to speak to this application or problem? Anyone?
Hi, Kip Cherry, 24 Dempsey, and I'll be really quick. I think, frankly, that the developer...
I'm sorry, excuse me, I'm going to have to swear you in. If you could raise your right hand.
Oh.
Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, I do.
So sworn and affirmed. Could you please state your full name and spell your last name?
Kip Cherry, C-H-E-R-R-Y, 24 Dempsey Avenue. I think we're making a mountain out of a molehill. I think the developer's attorney's making a mountain out of a molehill. I think that we're talking about the Princeton market here. We're talking about instructions from you all regarding fitting the house individually on each site, which obviously takes an engineering team and an architect. Nothing to do with the overall architecture of the house. It has simply to do with the overall design of each site to fit the environment. And this is Princeton. No one wants to buy cookie-cutter houses in Princeton, so I don't see that there's an issue here. I don't know why the attorney is so riled up about this, because I would think that any language that he wants to limit or design in his contract with the builder, he should do, and move on. Thank you.
Thank you very much. Anyone else? All right. Any further points from the board? Okay. All right, so if there's no further discussion, is someone willing to formulate a motion to?
I would just ask, can I ask one more question of the Attorney. So I don't know if if you explicitly said this or if it was explicitly asked, but I mean, it seemed like you were planning on selling this to Toll Brothers, and you're looking to build, I guess, basically the same model for every home.
It would be, if pretty much everybody knows what they look like, they would have, the way that would go if it was this buyer is they'd probably have a number of model homes, right? Say 5 or whatever they say, 6. And the way they usually do it is, you know, when people come to buy, and if they're affluent people, they're going to want to put their own twist on it. So they're going to change this around or that around, the look of the house, maybe a garage here, a room there, here and there. So the houses will each be different, but they won't be as if you had a private architect from Princeton come and just mold and shape it of his own thing. So it would be like a Toll Brothers neighborhood. They'd be beautiful houses, they'd be big houses, they'd be different houses, but they would have models. So you might go through the neighborhood, and if the a lot of people, because they're the affluent and they want the biggest house they can get, yeah, there might be a few of the same model within the neighborhood. I don't know if they would testify to be next to each other or not, but they would likely be different because everybody puts their touches on them. Nobody's going to end up with the same look. But you know, when you drive through, you might say, yeah, that's that. You know, that's that one, and that looks like that one. But they'll be different. You know, they'll look different, and that's how different they would be. Okay, so they're not going to be like what Mr. Cohen likes, where everybody gets their own and they start from scratch. But they'll be big, they'll be fashioned to the owner's likings, and they won't all be the same model because there's going to be multiple models. That's what it would be with this buyer if it happened.
All right. If there are no further questions, are we ready for a motion? Would somebody like to make a motion? Anyone?
Well, if the board is inclined to leave the language as is, it would just be a motion to deny the request by the applicant to eliminate the language.
I think I'm willing to make a motion. I want to make a little statement before I make the motion, which is, number one, I kind of agree with Kip. I think that there are examples in town of developments with unique individual designs. I don't think the developer went out of business. So I would encourage the applicant to re-envision this development as a higher level of development rather than continuing to fight over this provision. And then secondly, I want to say that my very first question was to try and give an opportunity to provide some kind of compromise language which would give us what we're looking for without necessarily needing an individual architect to design each individual home, and the unwillingness of the applicant to consider something along those lines induces me to feel comfortable moving to deny the request.
I'll second that.
All right. Any further comment, discussion? Do you want to call the roll on that, please? Eileen?
Mr. Cohen?
Yes.
Mr. Oakman?
Yes.
Mr. McGowan?
Yes.
Mr. Quinn?
Yes.
Ms. Sachs?
Yes.
Mr. Texani?
Yes.
Ms. Wilson?
Yes.
Mrs. Gunning?
Yes.
Ms. Spala?
I wasn't here for the hearing, so I'm not sure.
This is a hearing.
Okay. Yes. Thank you.
Okay.
Okay, thank you. Thanks for your time, everybody.
I think so with the modification. I think so.
we're only missing Julie, so he shouldn't have voted. She didn't call his name.
I'm recused. No.
What time is it? It's 5 after 9, and we're about to start on this ordinance referral on the redevelopment plan for Thanet Road. Would you like a 5-minute break before we start on that?
Yes, please.
All right.
Thank you.
We better get going again.
Went out? Okay. Just don't breathe on it.
Okay.
So I'm going to do resolution minutes because this is a hearing, but it's going to be quite short.
Okay. Don't get too short. We've lost everybody, or? What happened to that end of the table? Open left. Who are we missing? And a million conversations, right? Well, let's get back into order. Could we come back into session, everyone? The next item is an ordinance referral. It's the redevelopment plan for the property located on 100 to 101 Thanet Road. This is block 5502, lot 4. This is pursuant to NJSA 40A-12A7. Mr. Michael, are you going to start us off on this, or?
Yes, Madam Chair, thank you. What I'm going to present this evening is an overview of the process, where we are, and then I'm going to focus on what's the chore before the board this evening, which is to consider compliance with the master plan for the proposed redevelopment. So what you have before you this evening is a draft ordinance to adopt a redevelopment plan for the subject premises, which you just mentioned, located at 100-101 Thanet Road. The ordinance was introduced by the Municipal Council on January 30th, 2020, and it is now being referred to the Planning Board for consideration for compliance. So these are the topics that I'm going to touch on this evening. A little background information on the local redevelopment and housing law, an overview of the actual redevelopment site, overview of the redevelopment plan itself for the site, and then again, as I said before, to conclude with a discussion of compliance with our master plan and planning considerations. So basically, redevelopment in New Jersey, this is a definition from the Redevelopment Handbook, which is a helpful tool that all planners use in New Jersey when it comes to housing and redevelopment. And as you can see, it says the process to rebuild or restore an area in a measurable state of decline, disinvestment, or abandonment. These are some of the steps that we have taken, starting with the governing body, which then directed the planning board to investigate the area. The planning board worked on a proposed map of the area boundaries and a report. Then the planning board set a date for a public hearing about it and provided public notice. Planning board conducted the hearing and made a recommendation back to the municipal council whether to designate this as an area in need of redevelopment. Governing body decided whether to adopt the resolution designating this area this site as an area for redevelopment. And then the municipal council authorized the preparation of a redevelopment plan, which is now before the planning board. And this is where we are this evening to discuss whether the plan is consistent with our municipal master plan, the goals and objectives of the master plan. And this would be the next step when it goes back to the governing body. The the municipal council to adopt the redevelopment plan by ordinance. And this would be after public hearing. So these are some of the steps that have been taken. The Princeton Council initiated the process as a non-condemnation redevelopment study area. The Princeton Planning Board held a public hearing on December 12th of last year. The board determined at that time and recommended to the Princeton Council that the entirety of the study area is qualified as a non-condemnation area in need of redevelopment. The Princeton Council adopted a resolution on December 18th, 2019, designating the entirety of the study area as a non-condemnation area and directed our consultant at the time to prepare a redevelopment plan. Now we're going to just talk about the redevelopment site itself. Here's a site description. Basically, the study area is located in the central western portion of the municipality. It's at it fronts on the intersection of Terhune and Thanet Roads on the northerly side of Terhune and east of Harrison Street, if you can picture that section of town. Identified as Block 5502, Lot 4. On the municipal tax maps, the property is approximately a little bit over 15 acres. It is irregular in shape. And here are some of the dimensional aspects of the site. About 430 feet of frontage on Terhune Road and a little over 1,000 feet along Thanet. There's a cul-de-sac at the end of Thanet Road, and the depth of the property is about 1,400 feet measured from Terhune Road. And this is just an exciting chart showing you this breakdown. The site currently has 2 3-story office buildings, each about 55,000 square feet. And there's parking for 427 cars. So there's surface parking around these 2 office buildings. And these are set back from Terhune, not visible from Terhune Road, back on the northerly end of Thanet Road.
Just for the sake of clarity and in case people are watching from home and it might be confusing, the site in my mind's eye is more in the central eastern portion of the town, not the central western portion.
I think you're right. I stand corrected because it definitely seems to be in more of this northeasterly quadrant of the municipality. So thank you for bringing that to our attention. Some of the surrounding land uses, it's an interesting part of Princeton in that it's along the easterly side of what I would call the Harrison Street corridor. There, north and west of this subject premises are office uses, office and research. To the south and east are mostly residential uses, both multi-family and detached single-family homes. The Princeton Shopping Center is nearby to the south. It's within walking distance. And as you know, that's the shopping center with the municipality's only supermarket and other stores and services. There's also many medical and professional services along Harrison Street within a several block radius of this area basically to the south and a little bit to the west of the subject premises. The area is served by local and regional bus lines, and these have connections to downtown Princeton, the university, to the New Jersey Transit Station, and hopefully and of course that connects you to other destinations in the region. The site is also within walking distance to Little Brook Elementary School. It is not too far from Community Park and Community Park School. The charter school, Princeton Charter School, is nearby to the north and west of the site, and John Witherspoon and Princeton High School are several blocks away, but within walking distance. Here's a map of the municipality, very much showing that the subject premises is within the northeasterly corner of the site. So glad we had a map of that to clarify. And in the bold white lines, that outlines the subject premises, 101 Thanet Road. You can see the 2 office buildings and the surrounding surface parking lot. And the buildings are in close proximity to the end of that cul-de-sac, the northerly side of the cul-de-sac. And the parking surrounds the buildings to the west, north, and to the east. Just to get your bearings of the area, immediately sort of to the northeast, to the right of the subject premises, across that line, you can see the Governor's Lane residential neighborhood. A little bit below that and immediately to the east of the subject premises is a property, 29 Thanet, which is another office building that's not part of this redevelopment plan. And then you can see to the south and to the east other residential properties. Terhune Road at the bottom of the slide to the south. There's a medical office building at the corner of Harrison and Terhune, other office and research buildings to the west. And then if you can see that intersection, the fork of North Harrison and Bunn Drive, there's the Princeton Charter School. This is a colored map showing the land uses. Again, the area in red is office and research. The blue is the Princeton Charter School. The orangish color is multifamily residential, Governor's Lane mostly in that area. And then the lighter yellow, greenish yellow color is more a lower density single family residential. This is a map showing the environmental conditions of the subject premises in the surrounding area. So it gives you a sense of where there's streams, a 100-year floodplain, other bodies of water, and wetlands. Just to give you an overview of the actual plan that's before you, the redevelopment plan is a component of the municipality's December 2019 settlement agreement, which is between the municipality of Princeton and Fair Share Housing Center of New Jersey. It's a component. There's obviously many other sites that are part of this Fair Share Housing Plan for Princeton. Princeton has also entered into a memorandum of understanding with the developer Avalon Bay Communities and an affordable housing agreement with Pearl Developers, another developer, to provide the perimeters for the redevelopment plan. You'll see there's two basic components of the redevelopment plan. Two new zone districts are proposed within the redevelopment plan. The first zone will facilitate the development of a 100% affordable, age-restricted rental development. This will contain 80 rental apartments. It'll be limited to occupancy by residents 55 years or older. And funding for this project will come from a number of sources, including the municipality and low-income tax credits. The second zone is intended to facilitate the development of a privately funded inclusionary development containing no less than 221 units, dwelling units, including a minimum of 11 COA credit-worthy apartments, 5 of which will be reserved for special need individuals. All the dwellings in Thanet Road non-condemnation redevelopment area are to be rental. There will be no ownership opportunity. And this map, please ignore the legend because the legend is wrong. The red is the area that will be developed by Avalon Bay and is the inclusionary rental apartment district. Let me see. I'm sorry, did I get that wrong? Let me see. The red, let me start with it. The blue is the residential senior affordable district. And the red is the inclusionary rental apartment district. I knew I wasn't going to get that right, and I apologize for the confusion from the legend. But that shows you the layout. So there's actually 3 sections. The upper and lower one are the inclusionary rental apartment district, and then that center blue one, it will be where the senior housing will be constructed. And there's 2 concepts right now that are very similar that are being considered as part of the redevelopment plan. What you see in front of you, Thanet Road's at the center there. This first concept calls for some, in terms of, well, I'll start with the senior housing is that red-lined building at the center. It's sort of upside down, backwards L. If you notice, it's on the upper part of the cul-de-sac. And then to the right and to the left of it, in the darker shading, are the buildings that would make up the inclusionary rental development by Avalon Bay. The larger area at the end of the cul-de-sac, there's a community building. There'll be a combination of townhouses, a building up to 5 stories with flats and apartments, a mix of different unit types. And then this concept also shows some townhouses to the left, if you notice, on Terhune, near the intersection of Thanet Drive and Terhune Road. Thanet Road and Terhune. So that's the one concept. The difference between this and what we call concept 2 is that those townhouses, instead of being out on Terhune, are now along the what is actually the westerly side of Thanet before you get to the bulb of the cul-de-sac. If you can see that, they're closer in proximity to the senior housing site. Everything else is pretty much the same. Planning conclusions. The plan does promote the following Princeton master plan policies. It will diversify Princeton's housing stock, providing affordable housing opportunities for a variety of community housing needs, including family, seniors, and special need housing. We believe it will protect the natural environment because the new construction will take place largely on sections of the site that are already developed, whether it be existing building or existing parking area. So it's basically reusing sites that have already been disturbed and developed. The proposed development integrates the development in a manner that protects the character of existing neighborhoods with appropriate development standards. We feel that it will fit into its surrounding area. The plan requires developers to pursue traffic improvements that will hopefully integrate the development well into the surrounding neighborhood, and we want to improve road conditions, walkability, access to transit, and also safety in terms of traffic calming. We looked at the master plan for the county, the Mercer County Master Plan, and the plan does seem to be in conformance with the county master plan's goals and objectives of promoting redevelopment activities in a compact design. We think this follows that goal. It also promotes redevelopment that will limit stormwater runoff and increases green infrastructure. Those are priorities in the plan. It seems to be consistent with the goal of directing growth to transit corridors and centers. We believe the Harrison Street corridor is an existing transit service corridor that can be improved with the increase in population. We hopefully will develop even more convenient and frequent transit service from the existing bus service, and hopefully an enhanced shuttle and bus service. And then also, as I mentioned earlier in the presentation, destinations that are within walking and biking distance. And also, we see the shopping center in particular as a node of activity and an evolving center of activity within Princeton. And then again, seeks to encourage a walkable community. A high priority is to make connections to the existing trail and sidewalk system. The plan does promote the State Development and Redevelopment Plan by encouraging development and growth within the planning area 2 of the state plan while protecting established neighborhood and natural resources. So these are some of the conclusions from a planning perspective. We believe the plan advances smart growth principles, directing growth where growth should happen, where there are resources and infrastructure, and where multimodal accessibility is possible, and also being sensitive to the environment. So it talks about, this plan is a redevelopment of an existing underutilized and obsolete office development. I didn't mention this before, but the buildings are nearly completely empty, and they have been empty for quite some time. And the buildings are in a state of deterioration, as is some of the site, including the parking areas. The plan focuses development on these existing disturbed areas and retains the natural and environmentally sensitive aspects of the site. We expect it to provide appropriate stormwater management measures and also to bring stormwater up to date and be more current and effective. Since this is an older site that's been deteriorating, we hope there'll be improvement in stormwater management. It does provide for community interconnectivity. A lot of the discussion we've had with the 2 developers for the site have been about providing connections to the existing walking and bicycle trails and system in town. And then we feel it's a strategic location because it's along this Harrison Street corridor. It's close to the shopping center, transit, employment destinations, schools, medical services, and other retail shops and services. So this is just one last map, and it just shows you that yellow hatched area is the subject premises on Thanet Road, and then the darker pink and the lighter pink are the some of the medical office and research uses. The light blue, again, are educational uses. The darker blue is Westminster Choir College, which is a component of Rider University. And then the green is recreation fields and parks. The yellow line is New Jersey Transit bus routes. And the blue, you can see those blue little boxes, those are bus stops. So you can see how that Harrison Street corridor is really, it's already in place and it's starting to grow, and we think it will become even more convenient. So that is an overview of the plan. And if you have any questions, I'll do my best to answer them.
Questions? Anyone?
Somebody remind me, are there sidewalks on Terhune?
I'm sorry.
Yeah. On the side that Thanet Road is on, there's a shared side path that goes, I think, from Thanet all the way to Harrison, and at a certain point it turns into a concrete, narrower sidewalk.
So it is on the side of Terhune on the project subject premises side.
And it leads all the way to
northeasterly
Harrison.
side.
So it goes up Terhune and also down all the way to Harrison. So people could walk, theoretically, they could walk anywhere on those sidewalks. Okay.
And there's discussion under ways of improving those connections.
So you mentioned that there was inclusion of green infrastructure or mention of green infrastructure. I didn't kind of see every mention of it, but does the redevelopment plan explicitly say, you know, how much water is going to be captured or how green infrastructure will be used?
No, I think it sets forth that the DEP will have to approve, you know,
so it's kind of standard.
The system for the new use and the new configuration of the site. It's a little more conceptual.
Right. Right. And in terms of like the concepts, are those just there for kind of to give a sense, or how certain are those concepts? And was there discussion about like having more prescriptive architectural design kind of standards, because that's one of the advantages of a redevelopment plan?
Yeah, some of the issues that came up, the layout that you see reflected in the two concepts were a result of discussions that the municipality had with the two prospective developers to meet some goals such as staying within the existing impervious surfaces of the site and trying to retain existing, particularly perimeter green areas for screening from adjoining properties. Also, you'll see, for instance, it shows buildings, the buildings that are closest to the green area that's near the property line by Governor's Lane, instead of having the parking for the housing on the side to the east towards the adjoining properties, it's the building that the neighboring properties may see instead of parking, and the parking is on the interior of the site. So there were some considerations to try to wrap buildings around parking, obscure parking from view, and again, to stay on the areas that have already been disturbed by the office development. As far as actual architectural styles, it doesn't get to that level of specificity, but discussions have been made to try to keep the building heights as low, you know, to keep it as low as possible. Even though one of the buildings may be 5 feet in height, it's limited to 65 feet. So the idea is to really try to give some design constraints. So those were some of the considerations.
And, sorry, one more question. I didn't mean to hog the conversation. But is there parking minimums, or I mean, parking ratio? What's the parking ratio?
I believe in the report it says a ratio of 1.5 parking spaces per unit, which they felt was trying to be a little lower than usual for what a suburban development would provide. So the idea was to try not to have excessive parking on the site more than that was absolutely needed.
And there's a lower standard for the senior zone. It's 1-to-1.
1-to-1, exactly. And then there was also discussion of possibly land banking some spaces to see if all the paving area would be needed.
Other questions?
I have some.
Well, go ahead.
Okay. The concept concept plans, concept 1, concept 2, concept 1 is, oh, I'm so sorry. I happen to know from watching on TV that if you don't have this thing on, you cannot be heard at all.
Here's concept 1.
So, sorry about that. So the concept 1 and concept 2, and I think concept 1 referred to at some point as the preferred plan, is that
Some
correct?
members of the municipal council stated that they thought that would be the preferred from the community. At this point in the conversation, that's correct.
Okay.
And here's 2, just so everyone can see again the difference.
Right, that's the one with the townhomes fronting on Terhune.
Correct. Concept 1 has some townhouses fronting on Terhune at what you would call the gateway to the property. And then concept 2, the difference is that those townhouses go more into the interior of the site along Thanet, and they're in close proximity to the senior site.
Mm-hmm.
That's the major difference.
It specifies too that if concept plan 1 is what's built, that there's a 0 setback from Terhune Road, and I was wondering whether that's actually 0 setback from the right-of-way or actually from the road. Or right now there's a series of street trees along there, and then it's heavily wooded behind, and it drops off precipitously to go down to the creek that is always flooded. And there's a section of the townhouses on the right end of the plan, well, okay, on the bottom end of the plan as you see it on the screen.
You want this one or this
that
one?
seems to be within an area that is, dropping off. I'm just questioning whether you could really put townhomes extending that much along Terhune, and also would like to hear what your thoughts are about the 0 setback and how that would
I'll start
play
with
out.
that. The 0 setback, in addition to being what we thought would be good urban form to have the buildings right up to the right-of-way and where people are walking. And it's really also it reflects the situation with the constrained site, both the frontage on Terhune, as you've stated, there's right behind that is a depressed area where there's a stream, and it's a wetlands area. And then also in concept 2, there are also some concern about the constraints of the site because of environmental characteristics of the site. So that's where the 0 front setback came from, and it would be measured from the front property line, which is basically the edge of the right-of-way.
And I just wanted to comment, the right-of-way there is quite wide. It's a 90-foot right-of-way in that part of Terhune. So a 0 setback is probably a good way from the curb, because I believe the cartway is only 30 feet.
Right. It seems like you might even have to go into the right-of-way in order to fit those houses between the street and the drop off to the stream.
Right, and again, that's why there's 2 concepts, because we're going to have to see which one fits, basically, because of our environmental considerations.
So if we go to the other concept 2, my read of the MOU, and attorneys or others who have been more involved in this from the beginning should correct me if I'm wrong, but is that my reading is that these plans, concept 1 and concept 2, are what the developer is going to build. that they, I mean, what it says is the layout of the Avalon Bay development and location of the parcel, well, of course the parcel, but layout shall be consistent with the concept plans attached hereto as Exhibit A. And my concern about the concept plan is, I guess I'm curious about whether there was any thought to creating a grid of small streets or some kind of plan for the site that gives it more of a neighborhood character and reflects, it's not a downtown thing, but reflects an urban design kind of touch, because there is the kind of density there that that is called for and that is consistent with the master plan. I'm not calling out the density, but the way that the site is laid out, it just looks as if from every dwelling you look out front and back onto parking. Or maybe not back if you're backed up, if the townhouses are back to back. So
Right.
So I guess I'm just curious about what you think about variations that could be contemplated, or whether we would be, locked in to this general type of site plan without any sense at all of what it's really going to look like and feel like, and where people are going to gather, and where the connections to the neighboring properties are likely to be,
Right.
and these kinds of basic things that you want to have control over with a redevelopment plan.
I think, again, a redevelopment plan is like zoning, but you do get a little more information and you do get a better idea of what the end product will be. As you know, with zoning, you usually see, like on a proposed subdivision, you'll get a dashed box that shows where the setbacks will allow you to build, but you have no idea within that box, get a real sense. I think what's interesting about the redevelopment plan that you see before you, and I will agree with you that in a perfect world, I would always prefer a infill development type project to be part of a grid system where you're really connecting up with other neighborhoods, and you have multiple routes to take. It distributes traffic. It gives people choices. But I think, unlike this being in the former borough or the downtown area or within an older neighborhood, this is pretty much in character with what's in that section of town. For instance, Governor's Lane is a singular road that serves a large multifamily development. And I think the two concepts have some more new urbanism aspects to them, such as concept one does propose the townhouses up on Terhune, more or less filling a gap where there aren't structures, and it kind of ties in the residential development that is southeast of Thanet along Terhune. It kind of fills in that gap going northwesterly towards Harrison Street. So I think there was the idea of trying to do some infill development there. And then concept two, as you can see, the townhouses are shown here, hugging the front of the lot there and along Thanet. And if you notice, in both concepts, the majority of the Avalon Bay proposed development and the senior housing is right up to the cul-de-sac. So it's defining that space with buildings as opposed to parking lots and asphalt. So I think that might have an attractive profile if it's executed well. So I think, it's a cul-de-sac development, but keep in mind also that the whole concept of redevelopment at this site is to reuse as much of the existing infrastructure as possible. And I think that's a very green goal. I think that's a very sustainable goal, to use a street that already exists, to use disturbed areas that are already disturbed. Otherwise, if you go with a whole different kind of layout concept, you might be doing much more disturbance.
Yeah,
And also,
I was definitely not suggesting
Right.
that Thanet, be rethought of as some kind of straight street. But once you get to the bulb of the cul-de-sac, then you just choose this parking lot, that parking lot, or that parking lot.
well, I think it becomes a design challenge then.
So I just want to say, Louise, to your point, we did discuss that with the developer who's here and expressed concern about that. And the difference between this Avalon proposed property in Governor's Lane is that Governor's Lane actually does have the sort of interconnected streets that you're referencing. And the developer said that in order to change this parking configuration, it would require podium garages, and that would be an additional expense that they, at least at the point we spoke with them, were not willing to consider. I don't know if that might...
I'm really glad the councilwoman brought that up. I should have mentioned that because obviously in a redevelopment plan that involves affordable housing, cost is a consideration. And you know, the way they construct this it goes directly to whether the point that this will be affordable housing and to keep the cost at a reasonable level.
That's not exactly the conclusion that I would have reached, but yes.
I think you were mentioning, though, that it would be a different kind of development if it had structured parking. That was the
I think
point
that
you were raising?
it might be something that we would want to discuss further. That's what I'm saying.
Michael, the existing buildings will obviously be demolished, correct?
That is correct.
Okay, and the new units that go up, all 301, the 80 senior plus the 221 independent or, inclusive residential apartments, will all be rental? There'll be
Yes, rental.
Okay.
Michael, were there traffic figures estimated for the new development at all? We do have figures of the current situation, but did they estimate the amount of traffic that would be emptying out on Terhune Road?
We didn't have a specific traffic count given to us generated by our consultant, but I do recall comments made in the course of putting the plan together that clearly it'll be a different traffic pattern because instead of an office building with a sort of rush hour based flow of traffic in the morning and the evening when people working on the site would have come and gone, this would be a residential development with a different traffic pattern generated by both the senior housing and the other housing development. And our consultant at the time felt that the number would generally be lower, but that wasn't substantiated by actual statistics that I saw. I don't know if anyone else on the council that was involved recalls differently. I don't remember seeing a specific traffic analysis.
Yeah, I did not see anything either, and I think, to be honest, there's no traffic right now. So to talk about a comparison between an active office complex and an active residential complex is not really what we're talking about here.
But what they gave were the figures for the earlier one, the estimated figures if the office buildings had all been in operation. And
right. So to Michael's point, I think the commentary that we heard was that it would be a reduction in traffic compared to the existing use, if the existing use were in use.
right. Okay.
Just to follow up on Mia's point, I mean, I'm not a huge fan of parking garages, particularly looking ahead to hopefully more autonomous vehicles down the road. But I mean, isn't it really? I mean, you say that the developer says they can't afford to do something like that, but I mean, really, it seems to me like the way I understand this process is that they purchased this property at a low cost comparatively for what it is, and other than a piece of it going for senior affordable, which is being paid from other sources, they're basically providing 11 units of affordable housing out of a total of 221. So I mean, I think it doesn't seem to me like the burden of that affordable housing in terms of the cost should be overwhelming if to the point that they're sort of doing a reactive design that's maybe not what what we would like to see. Is that inaccurate?
Well, I can't really comment on that because I really don't have the financial, facts of the contract purchase or anything like that. I should have mentioned that the site for the senior housing is a gift of land from Avalon Bay proposed to the municipality. So, you know, I don't know if I made that clear before, but it is a transfer, a gift of land. As far as the profit margin or anything else, I'm sorry, I really can't comment on that. I don't know that information.
So, question about the senior housing. Is there a certain age? Are people that are going to be living there expected to have cars, lots of cars?
Everything we've been told from the consultants that we've been working with and from the prospective developer is that there is a very low demand for cars, you know, in these type of senior development, certainly lower than a regular market rate, no age restriction apartment building. So that we're hoping that's true, but it seems to be based on evidence from other similar developments.
Yeah, because I mean, I would share the sentiment about the parking deck. I mean, I think that that's certainly a better option than having extensive amounts of surface parking. But
I don't think
another option
we
is,
weren't proposing a parking deck. I think what we had thought was podium parking, which is, you know, integrated into each structure. And I think some of the buildings that they're proposing do have that, and others don't.
Yeah.
So,
thanks for correction. Yeah, I didn't mean like a separate parking deck, but yeah, something that would be structured in the building. I think that's certainly a better option than the extensive surface parking. But another option is to lower the parking ratio and not have that many parking spaces. I mean, I think that this site is supposedly going to be a smart growth site. I would agree with that. And it's going to be next to the shopping center, which will have more units and more activity going on, and it's going to have access to bus stops and you know, hopefully bike lanes that will go into town. And I think that, you know, the Avalon Bay should be attracting tenants that, you know, don't need you know, 2 cars per family or more. And so I think that there's definitely way too much surface parking in this concept. I think that also the design, I mean, it's based around the parking, and I think it could certainly be done a lot better. And I think that, you know, now is the time to actually be able to shape that design, because if we do that during site plan review, it's just going to be a matter of kind of nitpicking the details as opposed to actually having a say in terms of how this design looks. So I think, you know, we're missing a huge opportunity if we just kind of say that we're going to pass some plan that sort of has a generic, you know, overlay on top of the site and says that, you know, you have this setback and that height, as opposed to actually being able to design this site in the right way. So I'm just saying.
Okay. Other comments, questions, anyone?
Thanks for letting me speak again. I'm keenly aware that what we're tasked with tonight is to determine whether this is consistent with the master plan. And I do have concerns about, and I agree that in many ways it is. My concern is that there are some ways that it may not be, depending on how it's actually, in the final analysis, it's actually laid out. And, you know, the master plan speaks to maintaining a sense of place and traditional models of street layouts and building to a human scale and attractive and safe neighborhoods, and there's nothing here to tell me that that those things won't happen. but there's so little detail in the concept plans that, in my view, it may or may not happen. So I don't want to take action or not take action that is interpreted as undermining or blowing up the town's very, very careful work on all of this, and I don't know what our options are for not making a final determination one way or the other this evening. So I guess I'd like to know, Michael, from you, and also Jerry, from you, you know, what kind of options we have, and yeah, that's what I'm struggling with.
If I could
I'll start off, and then I would love Jerry to jump in, since I don't have our Affordable Housing Council with us this evening, so that would be helpful. But I would say that you're right. The major task that the planning board's charged with this evening is to find whether this plan, this redevelopment plan, is generally in compliance with our master plan. And when I say our master plan, there's a heavy reliance on our 2017 reexamination report, because quite frankly, our master plan that precedes the 2017 reexamination report is a vintage master plan, and it's you know, I think that's a kind way of describing our master plan. So I mean, it's more relevant because it said where we should go in terms of master planning in the future, and it mentioned things like this kind of redevelopment of existing sites and infill development. It's also quite vague, so it doesn't get down to that level of detail that you're talking about. But I do think we're going to have opportunities in the future to refine this plan. And I think, and maybe Jerry can tell me if I'm wrong, but if you were to decide that you wanted to report back to the council after tonight's discussion, saying that it's largely in compliance with the master plan, but here are some concerns, and give us some guidance in terms of design, I think that would be appropriate communication back to the council. Jerry, how do you feel?
Yeah, absolutely. In fact, the purview of the board is broader than just simply consistency with the master plan. The local redevelopment housing law says one of the things the planning board in these circumstances does is review the master plan in terms of consistency. But it also says, and I'll read from the statute, that it could make recommendations on any other matters as the board deems appropriate. So it's the purview is very broad.
And I'll just comment in line with Zenon's remarks that I think this really is the time to be giving design direction. And I like the tenor of the board's comments, which feel almost like a concept review as well as consistency with the master plan review. And I'd like to see that kind of information transmitted back to council.
Yeah, and it's perfectly appropriate.
Jerry, did we have until you gave a date? What was the date?
45 days from the date that it's referred to us, and that would be March. Yeah, I know. Hold on.
I believe it's March 16. It's on the agenda that I placed in front of you.
I think that's right.
You have the sheet?
I'm looking.
It's on the agenda that I gave you to read
I know.
tonight.
I know, that's what I'm looking for.
Yeah, it's March 16.
So we could also spend another evening discussing it if we need it. Is that correct?
Yeah. Yes.
Do we have meeting space between now and the 16th? I mean, this.
Well, if you move an application, yes.
Well, I think that's something that we're going to have to decide. But I would, in fact, we've got a lot of people sitting here listening to us, and I'd like to open the meeting to the public and hear what they have to say about this. Let's see, if every one of you spoke, why don't we say about 3 minutes would be the limit, and use the microphone up here. Give us your name and address.
That binder is getting thicker and thicker, Joel.
Yeah.
Shall we start?
I'm going to swear in all the members of the public. If you could raise your right hand, do you swear or affirm that testimony you're about to give will be the truth?
I do.
So sworn or affirm. Please state your full name and spell your last name.
Joel Schwartz. I live at 1 Armour Road in Princeton.
Excuse me, you're not getting picked up.
I'm sorry?
You're not getting picked up in the mic for the recording.
Joel Schwartz, 1 Armour Road, Princeton. Is that good? So I have a few comments about some specific proposed standards. And secondly, I'd like to point out, though I'm not addressing the master plan specifically, I believe that the consequence of adoption of those specific standards will produce a result which is contrary to the goals and intent of the master plan. So I have a series of very specific comments. On page 16, the redevelopment plan indicates that the municipality is going to waive all land use application fees as well as uniform code construction fees, et cetera, et cetera. Won't read the whole thing. It is not at all uncommon for that to be the case on projects that are 100% affordable, like the senior project. However, the Avalon project is not a typical 20% inclusionary project. It's a 5% inclusionary project. So
Joel, I just have to interrupt you because my understanding is that the waiver of those fees is only for the senior, not for the Avalon.
I read that again tonight, so you might want to double check to make sure there's no typo in the agreement. It seems to apply to both projects.
Yeah, it was actually originally in the document that we received, it was incorrectly included in both.
Okay.
But it's not the intention of the council to have it in both.
But the document that was introduced for first reading that I got off the web does seem to speak to both.
Joel, let me ask you, what is the date of the plan you have? The most current is...
the 29th.
Yeah, okay.
January 29th.
That's the most current.
Yeah, I read it again tonight. Second, we talked about, there were some comments about parking for the seniors at 1.1. Two comments. One, it's illogical to talk about parking as an overall ratio for an overall project because parking in this state is regulated by the residential site improvement standards, which has a specific number for each bedroom type. I understand that the 80, whatever the number is, there's X for one bedrooms, X for two bedrooms. Now, everyone has a different theory about if seniors have more cars or less cars, and maybe what's proposed works and doesn't work. But it's logical to approach this with the frame of reference being RSIS. The project is 55 and over, but under the 55 and over regs, 20% of the residents can be under 55. I'm 68 years old. I have as many cars, and I drive as much today as I did 30 years ago. So I'm not saying what's in there is wrong, but I'm saying that there's no proofs offered as to why this is correct. So I would urge you to look for proofs before you make a commitment to a particular standard without even knowing, for example, you don't know the bedroom mix in the senior building. So I don't see how you could be talking about the number of parking spaces on the overall project. Next, on page 17, there's a reference to simultaneously preliminary and final approval. And it begins with the language that Pearl's proposing 100% affordable development. Timing of funding applications becomes critical for financing of this type of housing product. I won't read the rest of it, but you can find it. The reason I bring this issue up is because it would be I'm sorry, the end of that paragraph, it talks about simultaneously preliminary and final. It makes a reference to section 10B-221 little a. One of the little problems I have with this document is that it gives citation numbers, but it doesn't say what the citation is about. And you all know, probably better than me, how difficult it can be to navigate online around the ordinance. So I don't know what that citation provides for. I do know that in this town, typically projects do not get simultaneously preliminary and final. I appreciate that this project has some funding constraints, but this is a 4% tax credit project. It's not just a once a year application. My concern is that, for better or worse, this town has a long history of you get preliminary, and then you don't come back to the planning board for final until you've satisfied your exhaustive list of conditions of your preliminary. One of the benefits for this town has been that the planning board and the town's professionals get a second bite at the apple. When a large, complicated project gets simultaneous preliminary and final, you get one bite, and that's it. So I'd urge you to take a closer look at that and decide if you need that for the senior project. That's one thing. It's not clear why it's necessary for Avalon's project. Again, that's a 5% project. It's not a 20% inclusionary project. Avalon is a big company, not without a lot of resources. And there, as I said, there's a benefit, as you all know, to get preliminary and then getting final. Next point. On page 19 through 21, there's a series of bulk and other regulations. A number of these standards provide what I think can only be characterized as an unprecedented degree of deregulation. And by this I mean that there's design standards which would be unduly permissive for any residential or even commercial district in this town, including downtown, including the most relaxed single-family zones. But this, in fact, will be one of the most dense residential districts in the entire town. So I'm going to walk you through a couple of the provisions that I would urge you to take a look at. Some of them have been touched upon. There are a 10-foot setback is unprecedented in any residential zone in town. There have been allusions made to new urbanism in the context of this project, but this is not a downtown project. If this were on Nassau Street, everyone would be very comfortable with a 0-foot setback. But 10 feet on Thanet Road, and for principal buildings, parking buffers are exceedingly small. There's a 1-foot setback for parking from property lines. There's a 5-foot setback from rear property lines. There's 10-foot setback from buildings. Now, you've also been talking about the fact that there seemed to be an absence of streets, conventional circulation. There's no streets, there's no conventional sidewalks. You have parking lots and buildings. If a parking lot can be 10 feet away from a building, what exactly is going on in those 10 feet? Normally, you'd like to have a curb, you'd like to have some green space, you'd like to have a sidewalk, you'd like to have some trees. The buildings can all be slab on grade. So if you have a parking lot that's 10 feet away from a building, that means that the people who are on that sidewalk are at eye level with the first floor residents of that building, with virtually nothing in between. So my point is that standards like that are so permissive that they actually contradict with values in the master plan and values that we all hold as a community about walkability. Because the essence of walkability is creating places for people to walk where they feel comfortable. And I would suggest that walking when you're 2 or 3 or 4 feet away from somebody's bedroom windows and kitchen windows and living room windows is not going to promote a comfortably walkable place. There's no reasons given. I won't belabor all the points. They're all obviously in there. I'm sure they jump off the page at you when they say 0 and 1 foot and 5 feet. There are no reasons given for why this extraordinary relief is necessary. The senior project is at a density of 32 units per acre. The Avalon project is 17 units per acre. 32 units per acre, the senior project, is slightly higher density than a garden apartment. 17 units per acre is the same density as a conventional 2-story garden apartment project, which were built all over New Jersey in the post-war years. So what do these densities really mean? They're not very challenging densities. It's not very difficult to achieve the project that both developers want to achieve. But the design standards are the kind of standards you would give to a developer who's either building in a center city or in a very, very difficult site with a very, very difficult program. But these densities are very, very low. It's not a matter of whether you're. I'm not against giving the developer a break. As many of you know, I'm a developer myself. I'm concerned about what these standards do in terms of our walkability. The last thing I wanted to mention has to do with page 22. There's a section about 3.6, building and design layout. There's a lot of words here, but there's not a whole lot of meaning. At one point in that paragraph it says, fenestration shall be provided on each building facade to the extent practical. That means that well, we're going to try to have windows on this building. That's not a very compelling design standard. It also means in plain language that there might be facades with no windows. I would hope that we could do a little better than that. That same paragraph goes on to say that the Thanet Road Redevelopment Plan has carefully considered building and design layout specific to the two districts created herein. As such, Section 10-B226.1 shall not apply to developments in the Thanet Road Redevelopment Plan. Question, does anybody know what that section refers to? I found what I think is that section, but as you know, our ordinances are a little bit confusing at times. There's no reference, there's no text, there's no information in the redevelopment plan that explains why that section of our ordinance, to which every project in this town has to comply, is magically not going to apply in this project. I'm just about done. I know you want to get the show on the road. There's also, apropos the line I just read directly from the redevelopment plan, what exactly is the evidence that, quote, the Thanet Road Redevelopment Plan has carefully considered building and design layout specific to the two districts created herein? This redevelopment plan was not presented publicly until 1 week ago. Everyone in this room knows that the document itself did not exist probably 2 weeks ago. So what exactly is the the reference that I just read twice that's in the plan? I appreciate your consideration. This is a hugely important project. Louise said something, Zenon said something that I'd like to pick up on. As a developer, I spent my first 20 years in development before there was a redevelopment law. So I know what it's like to do essentially downtown redevelopments without this statute. For the last 20 years, I've done many, many projects using this statute. Given the structure of redevelopment law, between the MOU and the way it's written, and between this redevelopment plan, if this redevelopment plan is adopted as written, I believe that that is pretty much the end of the matter in terms of what this board can do in influencing the design. Because there are two concept plans that are attached to this document, have also been attached to the MOU. That sort of paves the road for the developer to say, hey, we showed you this plan. If you have issues with this plan, I urge you to make them very clear. If you're perfectly comfortable with the plan that's been attached to two of the documents, then great. But my point is that between these standards, which are so permissive, they essentially allow the developer to do almost anything. And the concept plans basically put the town on notice that we, the developer, intend to build this plan. So thank you very much.
Thank you very much. Next person.
If you could raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, I do.
So sworn or affirm. Please state your full name and spell your last name.
Beverly Wilson, Wilson. I live at 447 Terhune Road, which is a block east of the Thanet Road intersection. So I know the area well, and you're right, it's a wonderful place to live. It's a great place to put people. But I have some issues with some of the specifics, and I'll only touch on two specific issues. One is the difference between Concept 1 and Concept 2. Concept 1, with that 0-foot setback, is going on a section, that's with the townhouses on Terhune. They're squeezed right up against Terhune because the land drops off very steeply there. There's no way you could fit buildings in unless they're squeezed up. They'll still be on the 100-year floodplain. There will have to be a lot of fill put in to make enough flat ground. And I frankly cannot understand why that is preferable to having those townhouses around the corner, less obtrusive, on Thanet. Both of these concepts do disturb the existing vegetation. What we have right now on Terhune is wild growth. You proceed from Harrison east past the medical center, which is landscaped in a way that makes you feel like you're walking by a park. And then you pass these woods, and then you reach single-family houses. And what you're proposing to do is take away the woods and put up a building that belongs in the center business district. not next to our residences. So I beg you, if you're making a recommendation comparing those concepts, please vote for concept 2 rather than concept 1. With the provision, as I will mention, my neighbor who lives on the corner of Thanet is worried about lights shining into her property. Again, this is something that's not strongly touched on in the development plan. But you have homeowners already there who are going to be affected by this development. I have lots of pages and I'm skipping everything I wrote. My other point is the traffic. There have been no traffic plans. There's no analysis. As I understand it, with 1.5 cars per family apartment and 1 car per senior, you're talking about 382 cars. And they're going to be going in and out. And so we're talking about a development with 382 cars and hundreds of people living on the end of a cul-de-sac that opens onto a narrow residential road. And there was discussion, it was mentioned in the council meeting that you're trying to acquire land to have egress out to Harrison or Bunn Drive. That's not in the redevelopment plan. There's nothing to make it happen. And I don't believe the council will have the power to force the neighbors to sell that land, because the ordinance specifically says that the council will not have the power of eminent domain to further the purposes of this plan. So I ask you to consider all those cars coming in and out, dumping onto Terhune. Everybody who wants to go east is going to go east on Terhune, which is already pretty heavily traveled. Or they're going to go south on Grover, which is even less suited to heavy traffic. Some of the traffic going north is going to come out and realize they can duck through the medical center parking lot to avoid the traffic light. And if there's a fire in there and you have hundreds of people trying to get out on the only road that the fire engines can come in, it's not going to be pretty. So I would hope that you would include in your recommendations that there has to be secondary vehicular egress and that it's got to be in there before this ordinance is approved.
Beverly, I just want to say one thing, that Janet has submitted, the woman who lives at the corner, has submitted a whole list of concerns that include lighting and generators, and those things, from what I understand, are more appropriate to be included in the redevelopment agreement as opposed to the redevelopment plan. And so they are being discussed. There's a separate document that deals with those issues, but that's very, very much being considered. And the other thing about the means of egress, I did bring that up at council, and I think it is very important. I do think there needs to be a full traffic study, given the level of density that's going in the entire area. And I don't know. I do think it's very impossible. They're very important to include this request for exploration. I don't know, Jerry, if that's something we can include in here. There are some other streets, private streets. I don't know if streets are the word, that go in and out of the property. And we had requested that Avalon explore easement rights.
There's a pedestrian path to the Church and Dwight property.
Yeah, just to respond to the question,
Okay,
yeah, you could add that type of recommendation to the report by the planning board.
Okay.
That would be useful.
Thank you.
If you could raise your right hand, do you swear or affirm that testimony you're about to give will be the truth?
Yes.
So sworn or affirm. Please state your full name and spell your last name.
Chris Foglio, Foglio, 111 Mercer Street. Unlike the developer that was chosen for this project, I actually own and operate 1,800 units of affordable housing for seniors in New Jersey. And what I'm most concerned about is the parking ratio. So the trend an affordable senior that's 55 and over, and I'm 58, is that younger people live in these buildings. This is not a blue-haired kind of let me retire population. And we're seeing the averages in these properties go lower and lower. About 50% of our residents in all of our COA affordable senior housing in New Jersey still work when they occupy these buildings. So over time, people age in place, and then we hopefully get them to leave a car somewhere else. But when you first occupy this, there will be cars. The only thing that's different, if you look at the averages of parking spaces for low-income housing, is if you look at the ones that compete for 9% credits, this is not competing, you are required in order to get points to have transit to support the property. So if you are going to consider a reduction in a parking requirement for this property, then I think you need to consider that there is an alternate subsidized transit support system so that you can convince the residents not to take their cars. That's normally the industry way of reducing the per unit parking requirement. The other thing is that since Sandy, there's a very strong movement to emergency services for active adult multi-story communities. I would suggest that that be reviewed in terms of this building. For example, in all the buildings that I currently build, we put a generator. I didn't hear anything about generator services or if there's been input from the Princeton emergency staff to look at policies and procedures. I can just tell you that it really wasn't the flooding during Sandy, it was really the loss of power that impacted residents the most. And so those would be some of the considerations as you're looking to the plan that I'd like consideration for. Thank you.
Thank you.
David, I'm wondering if you can speak to, I know that generators were in the original plan that I reviewed and subsequently they were taken out. I'm just wondering, do you know why that was?
I know there was some back and forth on it and a sense on the part of the developers that, you know, there would be all the emergency power for egress and stuff that's required by code, but they didn't think that it was necessary to have the generators for, you know, for those kinds of storm events. I appreciate the comments, and I think we'll come back to the developer and pursue it further. And I'll similarly mention that we have been in conversations about a subsidized shuttle system.
Hello.
Very sorry.
It's okay.
I'm very sorry. If you could raise your right hand. Do you swear or affirm that testimony you're about to give will be the truth?
Yes.
So sworn or affirm. Please say your full name and spell your last name.
My name is Marta Davila, D''A''Avila. I live on 46 Clearview, so it's outside of the shopping center. We have a gate that opens to the shopping center. I live in that neighborhood because of the walkability and because it's a wonderful neighborhood to be in. So I don't dispute the fact that, yes, it's an ideal place for people to live and walk to all of these amenities. I have serious concerns with this plan. The first concern I have has been mentioned before. There hasn't really been an evaluation of what the traffic impact is going to be in the neighborhood. This is only one of several developments that is predicted to be going in the neighborhood. I imagine it's about 600 units that are being discussed as possibly being put in the North Harrison neighborhood. And I don't see how a traffic study was not part of this, because this is going to have a serious impact to the neighborhood. Also, if you have apartments that cost an average of, I'm supposing they're going to cost around $3,000 a month to rent, and you have a couple, They're certainly a working couple. They have 2 cars. They don't have 1.5 cars. The seniors also will probably have more than 1 car each. So I think that that's a very important component that should be looked into before the plan is approved. I understand that you're here to just evaluate if the plan complies with the Princeton Master Plan, but it doesn't seem to me that there is a complete thought of the whole impact of the development in the neighborhood. I also worry that by agreeing to the plan tonight, you're going to be basically set into this plan that is shown here, and we might not have a lot of flexibility. My understanding is that when you are setting a new ordinance for a redevelopment plan, you have some kind of leeway. You can, like the township or the council, can determine what happens in that site. So there are a lot of these things that are being discussed tonight that maybe the town can say to the developer that should be incorporated into the plan. There's another thing that, again, does not necessarily pertain to what you are supposed to be doing tonight, but the impact that this is going to have in our schools is very, very large. Littlebrook School is to its capacity already, and it's supposedly going to go up to, I don't know, 65% over the capacity with all these new units that are coming. And what's going to happen is not all these children are going to be able to be going to the Littlebrook or the CP schools, and they are going to be bused. So that's another component that needs to be evaluated. Are we going to have school buses in that neighborhood? How many of them? How many times? You know, how many trips are we going to have, and so on. So I would just like you to give that some consideration. Thank you.
Thank you very much.
Kip Cherry, 24 Dempsey, and I was already sworn in. I have a couple of concerns here. I think there's a lot of issues regarding how compatible this is with the master plan.
Yes. You were actually sworn in on the prior hearing.
That's correct.
So I'm going to have to swear you in again for this one. If you can raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
So sworn or affirm, please state your full name.
Okay. Kip Cherry, CHERRY, 24 Dempsey. There are a couple of points I want to make, and I think we've already discussed traffic a little bit, so I'm not going to get into that at all. One is sustainability, and I find that we're, again, as Joel has mentioned, and I really endorse everything Joel said and everyone else, we're losing our standards here because we've been envisioning becoming more sustainable, and yet we have verbiage in this plan that talks about solar ready. What is solar ready? It's nothing. So we have for the IRA district, solar ready. We have for the RSA district, compatibility with the Department of Energy, zero energy ready home national program requirements, which is pretty much just Energy Star appliances. So, I mean, I don't see anything sustainable here. I'm really disappointed, and I don't think this is at all compatible with our master plan. So far as stormwater and wetland preservation, I think that's a big issue, and I don't see much in the redevelopment plan about that. I'm very concerned about a lot of material coming into the wetlands and that the wetlands can't handle, and that the wetlands, really take a real hit. And now I would like to say also that in looking at the character of the neighborhood in terms of the master plan, there are no 5-story mega block projects in the neighborhood. There are none of those projects in our town. I don't know why people say it's compatible to other residential in the area. I don't see that at all. I don't know that people really envision how big this really is. And that's what I really want to talk about, is the mega block right in the center of the site. My understanding is that this is a wood frame building. Fire safety is a big issue. And unfortunately, New Jersey is a bit behind the 8 ball. We've had bills in the hopper to improve the state building code. They have not passed yet. And New Jersey is also slow at adopting changes in the building code. So, regarding the verbiage there, the reference to the state building code is not up to snuff at all. It's not good at fire safety. And we shouldn't rely on it. So, I think that there should be real specifics about what should be done for fire safety and not a reference to another code. Specify exactly what it is you want. I would say that a mega block that's over 7,000 square feet, which this is much larger than, really should be built of masonry. It should be not built of fire-prone material. We have a major problem with fires in this state. All over the country, we have major fires with wood frame construction. We've had a number of mega fires in our state. Maplewood, Edgewater, and we had our own fire here, which fortunately was not a mega fire because the building was not connected. But right here in Griggs Farm, we had a fire and we had the loss of a life. So we need to be very careful about just saying, oh, well, the code will see us through. Besides the masonry issue, there should be firewalls if it's not masonry, and the firewall shouldn't be more prevalent or less prevalent than 18 units. It shouldn't be a mega block with a firewall, one firewall, something of that sort. Ideally, we would break up the mega block into several blocks of 7,000 square feet each, and there would be space between each building, 60 feet, to allow for essentially a fire opening, an open space that prevents fire from jumping from one building to another. And believe me, that really works. I've seen fires like that, and they haven't jumped. We have a comment before that maybe the state has, or the federal government has passed a statute related to fire watch. So far, I haven't found any sign of that. I don't know where that is coming from. There was an effort in the International Fire Code to update it to include fire watch for 2021, but that hasn't been implemented by New Jersey. New Jersey hasn't implemented anything close to anything that's coming up in 2021. So just, a reference to the state building code being a requirement for fire watch, that's not true. So I think that you should, and how far you can go regarding the compatibility with the master plan on the fire safety, I'm not really sure legally, but I think you should be as specific as you can be in what you want to make this project compatible to the master plan. Thank you very much.
Kip, I just want to respond on the specific issue about the fire watch, as I was at a lunch for the new professional firemen who are starting this week over at the firehouse today. And we had a discussion about that. It's actually new regulation in the New Jersey State Fire Code, not the building code.
Right.
And they assured me that it is coming online in July. So
it's in the internet, from what I can tell, it's in the International Fire Code. It's for 2021.
This is the New Jersey Fire Code, and it's being updated right now. They knew exactly what I was talking about. It's a 24-hour fire watch, and it's coming.
Right.
It's being worked on right now and coming online in July. They told me, and
Well,
I'll get you the number of.
Yeah, I'll check on that. But another thing about a fire watch is people think sometimes the fire watch is a lark. It's just somebody who's kind of walking around, looking around. So you have to be very clear about what a fire watch is, what the qualifications of the person, what they're looking for, what they're supposed to do, what they're supposed to check, all that sort of thing. And I'll give you as an example, when the Avalon Bay was under construction here, there were propane connectors to the heaters that are used for drywall. And as far as we can tell, the Maplewood fire, which was a huge mega fire, was started because of a malfunction in a propane heater. So we brought that to the attention of council. We had some pictures. And essentially, it was the very next day that those propane heaters disappeared. So, once the issue has been made clear, there is action that will be taken. I'm sure no developer wants a fire, but beyond that, once the public is aware of it, and that sort of specificity needs to be in the fire watch. Thanks.
I do. I do.
I'm sorry. You swear or affirm to testify as to the truth. You swear or affirm that you would testify as to the truth.
I do.
Yeah, good. Could you please, sorry, very sorry. Please state your full name for the record.
Carlos Rodriguez, 201 Moore Street. I am also a professional planner and a fellow of the American Institute of Certified Planners. I just have a few comments on the consistency issue. The frame of reference for the consistency determination is not...
Carlos, your microphone, it needs to be turned on.
The frame of reference for the consistency determination are not some vague policies that might be found somewhere in the master plan. It's actually what the land use plan determines. And your master plan, which was adopted in December of 1996 and last amended in December of 2009, according to the land use plan element of your master plan, this zone, the land use designation for this parcel, is office research, which is what it's zoned for and which is what is there now. So I'm having a little trouble understanding how this board might find that this redevelopment plan is consistent with the master plan when clearly the master plan does not contemplate housing of any kind on this parcel. And none of the housing elements, fair share plan related documents that have been adopted since 1996 contemplate housing of any type on this process. So that's just one observation relative to the consistency determination. Understand that if you found the plan to be inconsistent with the master plan, the governing body has the option to adopt it anyway. But you would have your hands clean because, in fact, you've compared it to the master plan, and whether or not you agree with what's being proposed, you found that it cannot be deemed consistent. So that's an observation on that. With respect to the walkability of this site, know that this site scores 44 out of 100 on the walk score, which is a metric that's widely used by planners and realtors and other professionals to measure how walkable any site in the United States is. So this building where we're in tonight is 62. Not stellar, but 50% better. So I would question the idea that under current circumstances, without substantial improvements to the entire surrounding area, including its land use pattern, that you can honestly deem that site to be a walkable site. And even with respect to bikeability, the bike score, which is the other side of that same algorithm, the site scores 55 out of 100, as opposed to 78, this site where we are tonight. Okay. Now, with respect to the plan itself, I share many of the concerns that Joel expressed. I think the bulk standards need to be seriously looked at again. Understand that the plan currently states that setback from Terhune Road. It doesn't say setback from Terhune Road right-of-way. It doesn't say setback from Terhune Road curb. It says setback from Terhune Road. I don't know what that is, but it shall not be less than 0. In other words, don't encroach on Terhune Road, but I'm not really sure whether that means the right-of-way or the cartway or something in between. I think those kinds of things need to be clarified and tightened up. And the other suggestion that I would make is that you lose those concept plans. Those concept plans are ludicrous. They are 1960s graduate student housing. There are these buildings surrounded by parking in every direction. That senior housing, proposed senior housing building, one side of it looks on a gigantic parking lot. The other buildings are surrounded by parking. There's no effort, none whatsoever, at placemaking. This is like a plan that was designed by the traffic engineer. You know, find some urban designer to do something a little better. I think our town deserves something better than throwing these building footprints out, surrounding them with parking and streets, and calling it a day. And, by the way, putting affordable housing in there as well. So that's my 2 cents. Thank you very much.
Could I just request, Carlos, if you can supply the worksheets where you got the calculations of the walkability and bikeability scores? I think the board would be interested in seeing those.
From my phone.
That'd be great then. Please,
I mean,
please
all
forward
you have
them
to
to
do
us.
is Google walk score, type in the address, and it'll give you the number. It's as simple as that.
I would need to know what it's based on. I mean, hopefully there's more
You want to know
detailed information.
You
Than,
want to know the algorithm itself? I think the algorithm is proprietary.
well, okay.
Yeah,
Then it's
sure.
not very useful information to us.
Well, it's used by 100,000 realtors around the country and by many thousand planning professionals. So,
I mean, from a purely common sense point of view, this site seems very walkable to all of, well, I'm not going to speak for everybody, but to everybody who I've talked about it with. So if we're hearing something contrary from you, I'd like to know what it's based on. And
I'm just giving you what the algorithm gave me.
okay.
And this is an impartial, you know, it's an algorithm that applies to every site in the United States. So,
Carlos, I wanted to ask a follow-up question to Council President. The ratings that you stated for the subject premises, is that based on the existing condition and situation at the subject premises before any improvements are made?
it's based on whatever information the algorithm has.
But it's based on the current state of the property, is that correct?
Yeah, of course.
Okay.
They can't anticipate things that may or may not be built in the future.
But that's what the plan's doing.
Well, I didn't see actually anything in the plan that would improve
I just
the
wanted to be clear
walkability.
that, but the ratings that you stated for the subject premises is based on the current situation.
Yes, as of today,
Thank you.
20 minutes ago.
But it's, I mean, I think the point is well taken. I'm not, you can stand wherever you want. Because, I mean, when you look at it as when you just look at the walk time between the middle of the site where most people would be living and McCaffrey's, it's more than a half mile. It's,
It's less than from here. Why is the score for this building better?
I don't know. That is a great question. That's a great question. Maybe it's proximity to the public school or to the pool. Who knows?
It's more interesting.
But I think the point, the point about transit and subsidized shuttle and making sure, especially since there's senior housing there, that people have a way, in addition to walking or biking, to get to destinations, whether they be for employment or shopping or dinner or whatever, is a really good point. And my understanding is that that's something that has been discussed and is likely to happen, but I don't see it in the plan.
So there is discussion of a shuttle that Avalon has, I think it's under discussion, and that which would go back and forth from Thanet Circle to the shopping center and would connect with another shuttle from the shopping center to Nassau Street back and forth that Eden's, that owns the shopping center, would be providing in the context of their development.
I just want to make one more comment, which is that I believe Michael Laplace, in talking about consistency with the master plan, mentioned that he was relying most heavily on the 2017 reexamination report. You didn't cite either of those in the reference material that you were referring to. Did you take a look at that when you were talking about it being inconsistent?
I have taken a look at it, and it does not modify the land use plan. That's from the original master plan back however many years, and it doesn't mention anything about housing on this site.
I feel like I remember some consideration that this whole office zone in town is sort of struggling, and that consideration of rezoning the use was something to be considered.
Well, then, if that is in fact in that document, it would be a good thing for your plan to reference that, because that's the closest you're going to get to a direct connection to the master plan, right? The other thing, if I could just expand a little bit on the walkability thing, notice that you're walking the length of that cul-de-sac with no streetscape whatsoever, right? The buildings are all clustered in the back of the site. You may or may not have some townhouses fronting on Terhune, but the entire length of the cul-de-sac, there's virtually nothing to look at. Nothing. It's very boring, right? So part of the pedestrian experience is that there are interesting things that are happening. There's an animated streetscape. There is nothing of that sort here. I feel like there's another question.
Yes, I just want to point out, I went to the site and plugged in my home address, and my walkability score was 61, and I live 900 feet from a park and 1,200 feet from the second largest grocery store in Princeton. So I'm not sure if, it seems that I feel my neighborhood is extremely walkable, and sidewalks on both sides of the road. So I don't understand how I could get a 61 and this building could get, I think you said it got a 68, or was that correct?
This building gets a 62.
So I think that we would have to dig a little deeper into what the... Exactly.
To be honest, I don't mean to interrupt. I think it's kind of ridiculous to debate the merits of walk score, which is like a totally recognized national standard. So, I mean, we can debate whether the site is walkable or not, but I mean, I think that, you know, this is a standard, and the algorithm is proprietary. It's based off of many the assets and things in the proximity of the site that's in. So, I mean, I think that this is just kind of...
So we should accept something that is totally at odds with an actual experience that people in a neighborhood have every day. Is that what you're telling me?
I think that, you know, I could understand how it has a walk score of 44 at the current moment. I think that it might not in the future if we plan the area nice. But, you know, I think that, you know, if you compare it to a neighborhood in New York City or Philadelphia, which has a walk score of, you know, 90-something, you know, you just can't compare.
I just want to say, I think everybody's basically saying the same thing. And thinking about this site, one of the main concerns that everyone has is the connecting the residences to the amenities at the shopping center and to transit, and it's definitely a top priority for everyone who's involved with designing and planning this, from what I've heard.
My experience, and just to finish off with this walk score thing, because I've used it in presentations before the zoning board and what have you, the closer you get to Nassau Street, the higher the score is. I pulled a score for 13 Bank Street, which is 100 feet from Nassau Street, and it had a walk score of 92 or 93, and the algorithm deemed it walker's paradise. I pulled a walk score for a property on the other end of Nassau, very close to Nassau, a block from Nassau, and it was 86. And so
I know everybody wants to go home. I wanted to offer, rather than ending on the subject of walk score, I'd like to end on a much more positive notion. One of the things that's hiding in plain sight on this project is that the 15 acres on this site are a cul-de-sac. It's next door to a 9-acre parcel, which is another cul-de-sac. It's immediately adjacent to 3 other office buildings, which are also cul-de-sacs. It's next door to Governor's Lane, which is a cul-de-sac, and the Italian-American Sports Club, which is a cul-de-sac. There's 100 acres of cul-de-sac in this area. Now, at the same time we're talking about this, there's someone who wants to come to Princeton and take an existing building that's been around for close to 100 years and convert it from its 100-year-old use to a hotel. So when that building became, I won't say if the hotel project is right or wrong, but when there's a need to repurpose a building on Nassau Street, people don't tear down 15 acres of infrastructure on Nassau Street. They look at a building and they reinvest in the building. On this site, it's worth asking, why is the solution on this site to nuke 15 acres of a lot of expensive improvements, right? The comments that Carlos has been making are highly ironic in the sense that the reason the buildings are so unvaluable that they have to be torn down is because there's no there there. It's just buildings surrounded by parking lots. Places that are designed like towns and cities are places that are continually desirable and valuable for thousands of years. So when something goes wrong with a building, we fix the building. We don't like nuke an entire neighborhood. That's generally a bad strategy. The plan the crit that Carlos made of the plan is that there's no there there. Ironically, the plan that's on the table is the residential equivalent of the office concept that's on the site now, which is so valueless that the only solution is to tear it down and obliviate it completely. The buildings next door are the same. The site is 100 acres that's at this intersection, bounded by all the 3 boundary streets. There's no way to get anywhere from in those 100 acres. Those 100 acres are the tip of 500 acres that stretches from Harrison Street to Snowden Lane, down Terhune, down Van Dyke, back to Bunn. If you drove around that entire huge block, which is probably 450 acres, I misspoke, it's about 3.5 miles around that. There is not a single through street in that entire area. There's a reason for why we're having this conversation, and that is that, also ironic, every weekend the streets of Princeton are filled with people who come from all over New Jersey who are dying to see a real town. For 300 years, Princeton has grown, developed, and redeveloped itself in the image of traditional town planning, which we see all over town. That pattern for 300 years gradually extended from downtown further out. When building stopped in this country on World War II, the high water mark of our urbanism in Princeton kind of ended at the Princeton Shopping Center. And after World War II, when development resumed, in this part of town, we stopped applying the lessons we had learned in 300 years of urbanism in Princeton, which is the character of the entire central part of the town. So this 458-acre super block and the 100-acre block that we're focused on is characteristic of suburban sprawl. There's no way to get there. One of the reasons the walk score probably does show up this way is that if you lived here and you wanted to get to the Princeton Shopping Center, you have a very unfriendly walk. So I would suggest that, I would urge that one of the subjects for you all to look at is to look at really, if this is a redevelopment is a look-back opportunity that you get very rarely in life. You look back and you say, well, when we as a culture, as a town, produced this part of town, maybe we didn't make the best decisions. We now have an opportunity to remake them, and so it would be great not to make the same mistakes that we made in the past. We all know that the other office buildings, it's just a matter of time, the same way that the office market has left this part of town, those buildings eventually will also become dysfunctional. It would be great to be able to apply the lessons of what made Princeton such a wonderful place to live in on this part of town.
Anyone else? Come on.
If you could raise your right hand, do you swear or affirm that testimony you're about to give will be the truth?
Yes.
So sworn or affirm. Please state your full name and spell your last name.
My name is Megan Mitchell. I live at 49 Clearview Avenue.
And how do you spell your last name?
Mitchell. I have enjoyed listening to all the points. I'm one of Marta's neighbors, and my main point that I want to reiterate is my concern with the context of this development in and amongst all the other developments that are coming down the pike in that same area. Ultimately, there's something like 700 and something units. That would very much change the character of the neighborhood. This development will alone cause Littlebrook School and the middle school and the high school to be over capacity. And I don't think there's any discussion of having it linked to traffic or the impact on the schools. And I think that's irresponsible. My fear is that the reason we're pushing for all of these things is to fulfill the affordable housing requirements, which I understand are important and very timely. I just don't feel like we need to sacrifice all of the design and the planning and the character of our town. We need to stand up for it in light of all the changes that are coming. The schools in particular, part of why people move here is for the schools. That's why we moved here. And the beauty of walking to your kids' elementary school or having them walk or bike there is amazing and something that makes Princeton incredible. And the thought of having to have kids bused across town, it happens at the Advanced Institute with those kids, but I think it will turn people away from our town, and in long term, in the short term, I think it's going to cause all kinds of overpopulation, which is already a problem in our schools. That's it.
Thank you.
If you could raise your right hand, do you swear or affirm that testimony you're about to give will be the truth?
I do.
So sworn or affirm. Please state your full name and spell your last name.
Sure. My name is Mike. The last name is Pisaro. It's P-I-S-A-U-R-O. I'm the policy director for the Watershed Institute.
You're not getting
sure.
things up.
Sorry.
Can't hear you.
Sorry about that. I'm the policy director for the Watershed Institute. I just wanted to follow up. Louise, you started this conversation, it seems like a long time ago now. So that concept 1 plan in that southern tier by Terhune, there are 2 tributaries to the Harrisbrook. I did some of the back of the GeoWeb mapping there. You may have about 90 feet from the edge of the property line to the riparian zone of that stream. And you may even have less of that given the township's stream corridor ordinance. That seems extremely tight to be putting development in. That seems extremely problematic when you have a lot of the neighbors downstream from that development that are already flooding out, that are already experiencing stormwater problems, that you are going to somehow shoehorn the development in with concept 1. And that seems to be inconsistent with at least the land use goals of preserving, protecting, and enhancing the natural and cultural and recreational resources, protecting the floodplains and stream corridors. And so that seems problematic, and I would urge the planning board to recommend to the council that that stream corridor be put into a conservation zone so that it is protected, it is not subject to degradation, not only for the protection of all the people downstream, but for that resource. So that would be one. Make that more consistent with the master plan by conserving that, putting that in a conservation zone. Other townships have done that during this redevelopment process.
Mike, can I just ask for clarification? When you say 90 feet to the riparian zone, do you mean the 300-foot riparian buffer?
Here, since it's a tributary to the Harrisburg, I think it's, for the state level, would be 50 feet. The 300-foot buffer only applies to C1 streams and their upstream tributaries. The township has a formula depending on floodplains and steep slopes, so it may be more. Obviously, if there's wetlands there, that would impact it. But again, I took a look. I pulled it up on GeoWeb, which is DEP's GIS. It's rough, but it gives you an idea that you're not talking about a lot of space between Terhune and the stream buffer. And if you put stormwater management in there, you're even losing more space. Which brings me my second sort of concern or request. On page 28 and 29 of the redevelopment plan, it talks about stormwater management, which I think is extremely good, but then it sort of, in my mind, caveats that in accordance with NJAC 7:8, which is the state stormwater rules. If this is a redevelopment site, it may or may not trigger any stormwater management rules. So if the township is of the belief that stormwater management will apply, I think it should be explicit in this plan that whether it triggers the rules from a major development definition or not, that stormwater management will occur on this site. I would also urge the planning board to recommend and the town council to implement that it would be green infrastructure. Your municipal code encourages green infrastructure. DEP adopted new rules that will require green infrastructure, and municipalities will have 1 year to come up with an ordinance to comply with that. You have the power in the redevelopment plan to put that in there. Hopewell Township did that when they were doing their redevelopment plans for affordable housing. I think you would benefit this community and all the downstream communities by recommending that go in there, that this will have stormwater management, whether it triggers the major development definition or not, and those things would be done by green infrastructure. You provide a lot of benefits for that. So I thank you very much, and I know it's late, so I will cut it off there, and I appreciate your time.
Thank you. Anyone else? All right. Thank you. All right. If there's no one else, why don't we close the public portion? Board members, it is now, what, very close to 11, a little bit after 11. We have a number of alternatives at this point. We can just pass all of this on to council on Monday and let them deal with it, or we can wait and carry it over to a second meeting and work up a list of all of these things that we need, that we and all of these citizens who came out feel really need to be considered further. So let me hear what you think about this.
Yeah, I would absolutely vote to, or motion to postpone till the next meeting, because I think that there is a lot of things we need to mention. So.
Anyone else? Mia? Okay.
I guess I would just like to suggest, if somebody wants to volunteer to try to summarize some of the areas of concern in some kind of document to bring back for the next meeting, so that we're not starting from scratch and trying to craft a recommendation to council.
Right,
Does that
That's exactly what we need, either an individual or a small group that could put together a series of proposed recommendations or recommendations to consider and have a document before the board so the board could use that. Otherwise, we'll be all over the place.
If the board members want to forward that to our office, staff can compile that list. I've taken notes this evening, so I have some of them as well.
I'm sorry.
Sounds like we have a volunteer.
That would be really helpful.
Kind of goes with the territory.
I do have sort of a threshold question, and that is whether or not the MOU has been signed and is in effect. It's the copy that I have of it is it says is made this blank day of December 2019. I got this from the council packet materials, so it wasn't part of it's not part of the redevelopment plan. It's the separate MOU with Avalon Bay, between the town and Avalon Bay. And the reason that I am asking whether it's signed and sealed and done is because on page 3, there's a paragraph that says, Avalon Bay, at its sole and absolute discretion, will prepare its plan generally consistent with the concept plans shown in Exhibit A. Said plan will be the basis for the eventual land use application. So I'm just, again, sort of revisiting, not trying to be to harsh everyone's mellow, but what, you know, I do want to continue to talk about this. I think there's so many ways to make this better, and people have raised really important points. But I also think that we need to go into that exercise with eyes wide open and understand whether any of that,
or whether we're wasting our time.
Exactly.
Maybe David or Tim could speak to that. That was, was that what you signed on December 18th?
Yes, the MOU has been signed, to answer Louisa's question directly. But I think that the developer's discretion may be influenced by the recommendations of the planning board, especially considering that they need to come back to this board for site plan approval. So, you know, everything's a negotiation. And it's possible that they'll ignore the recommendations of the planning board, but I don't think that's a reason for the planning board to not give recommendations.
Well, I agree with that then. Yeah.
Do we need a motion to carry this? Yeah. Does somebody want to make a motion to carry this?
I'll make it.
I'll second.
Second. Okay. It's been moved and seconded.
Eileen, do you have a date?
That was my question. Did you want to, there's two options. There's February 27th, which could be a special meeting, and I don't have to move Landwin, or March 5th, which is the Landwin application, and then the entire month of March slides.
I prefer the 27th.
Yes, I think that I do too. Anybody have any preference for moving everything to March? No. Okay, so let's tentatively then say that the motion says that we will carry this with an agenda or notes of this meeting for the 27th of the month. All those in favor?
Aye.
Aye.
Opposed? Okay. And thank you all for coming out.
Move to adjourn?
Second.
Yes.
Aye.
Aye.